Thank you for tuning into Bond Court. I want to continue posting Bond Court every night on YouTube, but the viewership and engagement on my channel has fallen off a cliff. I would greatly appreciate your help by hitting the like button and leaving a comment on my videos. Thank you and enjoy the show.
All right, we are now streaming live on YouTube. Good morning. Today is September 16th, 2022. Hold on 1 second. I am Judge Case Johnson. I will be presiding over today's matter. If you are having any problems hearing me, please let me know, as there are a few things I need to do. All right, there we are. Okay. Again, if you are having any problems hearing me, please let me know. There are a few things that I need to go over with you prior to starting the hearing. Listen carefully, as it will better help you understand the nature and the purpose of today's hearings. And as I said earlier, this proceeding is being streamed live over the internet. First, I am not here to try your case or have any legal discussions with you, not here to take a plea. The purpose of first appearance is to inform you of the charges against you, to advise you of certain rights, to set bonds for those offenses for which I am authorized to set bond on, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. Now, you have the right to remain silent, so please do not attempt to tell me any specifics about your case or any legal defense that you may have. As well as this being streamed live, it is also being recorded. Therefore, anything you say here today can and most likely will be held against you in future proceedings. Now, during this and all other proceedings, you have the presumption of innocence. You have the right to indictment by a grand jury for most felonies or accusation for misdemeanors. You have the right to a speedy and public jury trial, to compel the attendance of witnesses to testify on your behalf by subpoena, to hear, see, and question witnesses who are called to testify against you, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. And if you cannot afford one can be appointed to you if you qualify. Also, if you are not a U.S. citizen, some charges may adversely affect your immigration status, and you will need to consult with an attorney about that. Now, some of you will be allowed to post what we call unrestricted bonds for your release from jail. These bonds may be posted in 3 different ways: cash, commercial, or property. If you post a cash bond, you will deliver the full amount of the bond in cash together with any fees to the sheriff's office, who will hold it until your next court date, until your final court date, at which time your cash will be delivered or returned to the person who posted it. If you do not have the full amount of the bond in cash, you could also use a commercial bonding company who may take up to 15% of the bond for their fee. This amount will not be returned to you. You may also have someone post a property bond, so long as the net equity in that property is at least 3 times the amount of the bond, of your bond. For example, if I set a bond at $2,000, you must have at least $6,000 of equity in that property for it to qualify. Now, each of you will have as a condition of your bond that you are not to violate any laws while out on bond. But some of you will have additional special conditions that will prohibit you from going to certain places or having contact with certain people. If I tell you not to have any contact with the individual, this means that you may not text, call, email, write a letter to, or even contact through a social media platform. You can't even do something nice, such as send them flowers. If you do, it could land you right back here in jail. If I order you not to return to a particular location, please do not return to that location for any reason. If that particular location is where you reside, I will authorize you to go back for the limited purpose of retrieving your personal belongings that are not in dispute. Meaning, if there's any issue as to who owns that property, you must leave it there. You must make the appointment within 10 days of being released for the sheriff to accompany back to your residence. We do take special conditions very seriously. Now, unfortunately, some percentage of you will be back in custody on a bond revocation. Why? Because you didn't listen to me today. You'll get out, you'll go back to your residence, you'll get out, you'll go back to dating the victim, and it'll be all good until it's not good, until something happens, until you didn't call her back, or she didn't call you back, or something happened in a text message, or you went missing for some period of time, whatever the case may be. As soon as that person gets pissed off at you, he or she is gonna call the police, and then you're gonna be back in jail with no bond. It doesn't matter if the victim says, come back home, or talk to me, please. It does not matter, because they're not gonna be in trouble. You are. You're gonna be back here without a bond. Now, if the contact that you make with the victim, if the court considers it intimidating or harassing, you could receive additional charges. These charges include aggravated stalking or influencing a witness, and these charges carry a punishment of up to 20 years in jail and $20,000 in fines. Also, if your family member or a friend is the victim, that person will not be allowed to post your bond, nor would that person be allowed to come and visit you while you are in jail. For those family members watching via YouTube, please allow at least 3 hours after the conclusion of this hearing, so that before you start attempting to post bond, because it takes the paperwork some time to get through all the appropriate channels and process. Now, some of you are charged with offenses for which I'm not authorized to set a bond. In this event, a bond hearing will be scheduled for you in front of a superior court judge. If you are currently on active probation, this court is not authorized to set a bond. Whether a bond is appropriate will be determined once the probation officer has an opportunity to review your new arrest. Now, listen closely to this part. The purpose of a preliminary hearing is to determine whether there is enough evidence or probable cause to keep you detained on your charges. If you bond out, your preliminary hearing is automatically waived because you're no longer in jail. If you are charged with misdemeanors only, when you come before the court, I'm going to ask you if you desire to waive your preliminary hearing. What this does is simply moves your case from magistrate court to state court faster. That's it. It doesn't affect your bond amount. It doesn't affect any right that you have. It doesn't affect your ability to make bond. It simply just allows us to send your paperwork over quickly. I do not have any preference as to whether or not you waive or not. I do suggest, however, if you're not sure if you can make bond, I would not suggest you waiving your preliminary hearing. Now, finally, I'm about to read the oath to you. If everybody would please raise their right hands. Do you swear and affirm that the information that you're about to give this court, as well as any information you provided on your application for court-appointed counsel, is true and accurate? Yes? Yes? All right. All right, we're going to start with the females.
When y'all get up here, say good morning, Judge, and give her your name.
I'm sorry. Go ahead. Tell me your name.
Yeah, yes.
What's your last name?
Yes.
Oh, okay. All right. Is that Tia Nicole?
Yes.
Okay. All righty, Ms. Ailes. You are charged with DUI. That bond is set at $2,500. Wrong side of the road, $500. Driving on canceled license, $500. Expired or no license plates, $500. For a total bond of $4,000. And you must not violate any laws while out on bond. Do you understand the charges against you?
Yes, ma'am.
Do you wish to waive your preliminary hearing?
Yes, ma'am.
Are you able to bond out?
By commercial.
You hesitate. I'm going to go ahead and put you down for 9/27 at 8:30 a.m.
Now I'm trying to think of how I'm going to bond. So I was trying to do commercial as soon as I make the call.
Right, but that's fine. I just want to make sure that we, just in case you don't bond out as quickly as you think you are going to, you will have a court date. So if you bond out, don't worry about it. You don't have to appear.
Okay.
All right, good luck to you.
Thank you, ma'am.
State your name.
Good morning, Judge. My name is Ronke Allen.
All right, Ms. Allen, you are charged with battery, family violence. That bond is set at $2,000. Criminal trespass, that bond is set at $1,500. And false imprisonment, that bond is set at $8,000 for a total bond of $11,500. Yeah, $11,500. And you must stay away from Talisa Lawrence. And you must not violate any laws while out on bond. Do you understand the special conditions of your bond?
Yes, ma'am.
Because your false imprisonment is a felony, I have set your hearing date for 9/26 at 8:30 a.m.
I have to stay here till the 26th.
No, you can bond out. I'm just giving you a court date in case you don't bond out.
Oh, okay. Yes, ma'am.
Yeah, you got a little nervous then.
Yes, ma'am. I'm sorry. I'm sorry. Yes, ma'am. I did. I apologize.
I know. It's okay. All right. Good luck, ma'am.
Yes, ma'am. Thank you.
Good morning. State your name.
Samantha Baxter.
All right, Ms. Baxter, you are charged with interference with government property, crossing a guard line, possession of drugs by an inmate, in violation of Georgia Controlled Substance Act. All four of these charges are not bondable. I cannot set a bond at this time because you are currently on probation out of Cobb County, where you were sentenced to 3 years. And that sentence date was September 16, 2021. So currently you are on active probation and I cannot set a bond. All right?
So, yeah. All right.
And so hold on, but I'm sorry, hold on. I'm gonna go ahead and appoint you an attorney. Your court date will be 9/26/22. You have any questions? All right, good luck to you. Say your name.
Good morning. Sharika Bennett.
Good morning, Ms. Benning. You are charged with brake light violation. That bond is set at $500. No tag, $500. No license, $500. No insurance, $1,000. And child and not in a proper restraint, $500 for a total bond of $3,000. Do you understand the charges against you? You understand the charges against you?
Yes.
All right, and do you wish to waive your preliminary hearing? No, okay. I'm gonna go ahead and put you down for September the 27th at 8:30 a.m. It appears that you do qualify for a court-appointed attorney. Therefore, I am appointing one to you. Good luck to you, ma'am.
Good morning, Judge. My name is Aggravated.
Good morning, Ms. Brown. You're charged with simple battery. That bond is set at $2,500. Disruption of a public school. That bond is set at $3,500. That for a total bond of $6,000. And you must stay away from Clint Polk, and you must not violate any additional laws while out on bond. Do you understand the charges against you and your special conditions?
Yes, ma'am. And you said stay away from what?
Clint Polk, the victim,
Okay.
can't have any contact with, I guess it's a him, can't have any contact with him. I am appointing an attorney to you. And I have given you a court date of 9/27. If you bond out, you don't have to worry about appearing to this court date, okay?
Yes, ma'am.
All right, good luck to you. You're too young for this, Ms. Brown. Don't start. You starting out wrong.
Yes, ma'am. Yes, ma'am.
You don't like where you are, do you, right now?
No.
No. Okay, so that means hopefully we won't see you again.
Okay.
All right, good luck to you. Ms. Chambers?
Yes, good morning. My name is Keonda Shavers.
Chambers, you're charged with trafficking marijuana. I've set that bond at $25,000, and you must not violate any laws while out on bond.
Okay.
Do you understand the charges against you?
Yes.
I've set your preliminary hearing for September 26th at 8:30 a.m. Again, if you bond out, you don't have to worry about that court date. It's going to be waived. And I have appointed you an attorney.
Okay. So my bond is set at 25,000. Okay. Thank you.
Thank you so much.
Good morning, Judge. My
Good
name
morning.
is Jody Hardy.
All right, Ms. Hardy, you're charged with no tag light. That bond is set at $500, no tail light, $500, defective equipment, $500, and driving on suspended license, $1,000, for a total bond of $2,500. And you must not violate any laws while out on bond. Do you understand the charges against you?
Yes, ma'am.
Do you wish to waive your preliminary hearing?
No.
I'm going to set that for September 27th at 8:30 a.m. If you bond out, that preliminary hearing date will be waived, and so you will not have to appear. You have any questions?
Yes. What did you say for that one? Let me in.
I'm sorry.
The waive thing that you.
Preliminary hearing.
Yes, ma'am. What did that mean?
It just means that, remember, preliminary hearing is a hearing to determine if there's probable cause to keep you in jail. So I didn't waive it, so you don't have to worry about it. If you bond out, it's automatically waived anyway. All right? All right, good luck.
Good morning. My name is Deja King.
All right, good morning, Ms. King. You're charged with DUI. That bond is set at $2,500, and improper lane change, that bond is set at $500, for a total bond of $3,000. Do you understand the charges against you?
Yes.
All right, and you must not violate any laws while out on bond. Do you wish to waive your preliminary hearing? No? All right, I'm gonna set your preliminary hearing for September 27th at 8:30.
And if I bond, I don't have to worry about that, right?
And if you bond out, you don't have to worry about that. It does appear that you qualify for a court-appointed attorney, so I am appointing one to you.
I have a question. What, would I be able to do like a class or something?
You have to get with your court-appointed attorney.
Okay, thank you.
All right, good luck to you.
Good morning, Your Honor. This is Taya Odin.
Good morning, Ms. Odin. You are charged with aggravated battery. That bond is set at $15,000. Exploitation of an elderly person. That bond is set at $5,000. And you must stay away. What is Ms. McLaurin's first name?
Barbara.
Margaret?
Miss Barbara, B-A-R-B-A-R-A.
You must stay away from Barbara McLaurin, and you may not return to 5184 Jones Circle. Is that College Park?
Yes, ma'am.
All right, and you must not violate any laws while out on bond. I have set your preliminary hearing date for 9/26 at 8:30 a.m. And it does appear that you qualify for a court-appointed attorney, so I have appointed one to you. Do you have any questions?
9/26, I get an attorney, and then what, the bond was how much altogether?
Total bond was $20,000. If you bond out, you don't have to worry about that date.
Okay, yes, ma'am.
All right, good luck to you.
Thank you.
Good morning, Judge. Michelle Walker.
Morning, Ms. Walker. You're charged with theft by shoplifting. That bond is set at $2,000. You may not return to the Walmart located at 2940 Emma Block Road in Ellenwood, and you must not violate any laws while out on bond. Do you wish to waive your preliminary hearing? All right, I'm going to go ahead and set that for 9/27 at 8:30 a.m. It does appear that you qualify for a court-appointed attorney, so I have appointed one to you. Do you have any questions?
Ma'am,
No?
what'd you say?
I said, do you have any questions?
No, ma'am.
All right, good luck to you, ma'am. I believe that concludes all of the females. Oh, no, go ahead, I'm sorry.
I said, what is my bond again?
Your total bond is $2,000.
Thank you.
You're welcome.
All right, Judge, you're correct. That's all the females.
All righty, thank you.
All right, y'all good.
You as well.
They kidnapped me from the airport. They kidnapped me from the airport, bro. Y'all know my name. My name Kriston Curvey.
Your Honor, this is Mr. Baskerville.
All right, Mr. Baskerville, you are charged with disorderly conduct. And that bond is set at $1,500, and you must not violate any laws while out on bond. And it appears that you do qualify for a court-appointed attorney. You don't want a court-appointed attorney. I see where you wrote refused. Okay, I'm gonna go ahead and give you one anyway. And if you retain an attorney, then that attorney can just let the courts know that you have an attorney, okay?
My attorney name is Jillian Barzan. She is from Las Vegas, Nevada.
Okay, but I'm not sure. Okay, well, I'm not sure if she's licensed to practice here. So for now, I am going to appoint an attorney to you. And I'm setting your preliminary hearing date for September 27th in case you don't bond out. If you bond out, you don't have to worry about coming to this court date.
I bet.
Hold on one second, and you must stay away. Let's see.
From the mall. I gotta stay away from the mall.
Mr. Bakersfield, what's funny?
They kidnapped me from the airport.
Oh, okay. All righty, so, good luck to you, sir.
All right, yeah.
Brian,
State your name,
Christopher Grant.
Mr. Bryant?
Yeah.
Christopher Bryant, okay. All right, Mr. Christopher Bryant, you are charged with criminal trespass. That bond is set at $2,500, and you must stay away from Diane Balin.
Yeah, Ballin.
Balin?
Yeah,
Okay, and what is her son's name?
Denzel.
Denzel
Yeah,
Balin?
yeah.
Okay, so you must stay away from Denzel and Diane Balin, and you must not violate any laws while out on bond. Do you wish to waive your preliminary hearing?
David, does that make court faster or no?
It just gets you to state court faster, yes. But if you bond out, it's automatically waived.
Don't look at me.
So I'm just gonna put you down just as a precaution. That's gonna be September 27th at 8:30 a.m. And that's gonna be via Zoom. Again, if you bond out, you don't have to worry about it. All right, you have any questions, sir? All right, good luck to you. Go ahead. I'm sorry, what were you about to say?
Officer had twisted my arm, like my arm just feels so weird, like my whole arm is sore.
All right, so you may want to see if you can get post bond, so maybe you can go to the doctor to see what's going on with your arm. But any other issues related to your case, just talk to your attorney about it.
Okay, thank you.
I have appointed one to you.
All right.
All right, good luck to you, sir.
Burleson.
All right, Mr. Burleson. You're charged with obstruction. I've set that bond at $500, and you must not violate any laws while out on bond. Do you understand the charge against you? And do you wish to waive your preliminary hearing?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
Okay, you're gonna be able to bond out?
I think so.
I'm sorry?
I think so.
Okay, well, you said I think so, so I'm gonna go ahead and put you down for September the 27th at 8:30 a.m. in case you don't bond out. And it appears that you do qualify for a court-appointed attorney, so I have appointed one to you. Good luck to you, sir.
Carson.
All right, Mr. Carson, you are charged with aggravated assault by strangulation. I have denied that bond. Criminal trespass, I've given you a bond of $2,000. Aggravated assault with a deadly weapon, in your case, a knife, that bond is set at $15,000. And simple battery, that bond is set at $5,000. The total bond without the strangulation is $22,000, but you won't be able to bond out because of the no bond on the aggravated assault. Once you do make bond, you must stay away from Valerie Carlson and Nelson Irabor, and you may not return to 10146 Commons Way in Jonesboro, Georgia, and you must not violate any laws while out on bond. Do you understand the special conditions of your bond?
So I came by.
I'm sorry?
First one you denied.
The first one is denied. So your preliminary hearing date is scheduled for 9/26. All right, good luck to you, sir.
Harris.
All right, Mr. James Harris?
Yes, ma'am.
All right, Mr. Harris, you're charged with trafficking marijuana. I've set that bond at $25,000, and you must not violate any laws while out on bond. Do you understand the charge against you?
Yes, ma'am.
I've set your preliminary hearing date for September 26th at 8:30 a.m. I'm going to go ahead and appoint an attorney to you. Do you have any questions?
No, ma'am.
Good luck to you. All right, state your name for the record.
Lloyd,
What's your first name?
Travian, ma'am.
Anthony?
Nah, Travian.
Travian, all right. All right, Mr. Travian Lloyd, you're charged with criminal trespass, damage to property. That bond is set at 1,000, giving false name 1,000, and pedestrian walkway violation 500 for a total bond of $2,500. And you must stay away from Shanikia Hearn, and you must not violate any laws while out on bond. Do you wish to waive your preliminary hearing?
No, ma'am.
Okay, I'm going to go ahead and set you down for 9/27 at 8:30 a.m. It appears you do qualify for a court-appointed attorney, so I am appointing one to you. All right, good luck to you, sir. All right, Mr. Obi, you're charged with no tail light. That bond is set at 500. No license on person. That bond is set at 500. Giving false name. That bond is set at 1,000. Possession of a firearm by a felon, 8,000. Possession of a weapon during a crime, 5,000. Theft by receiving stolen property, 2,000. Possession of marijuana, 1,500. Violation of Drug Controlled Substance Act, 2,500. Use and possession of drug-related objects, 500. And carrying a concealed weapon, 5,000. Hold on one second. For a total bond of 26,000, and you must not violate any laws while out on bond. Do you understand the charges against you?
Yes, ma'am.
Your preliminary hearing is scheduled for 9/26 at 8:30 a.m. You bond out, that court date is waived. You have any questions?
No, ma'am.
All right, good luck to you, sir.
How you doing? Set your paramount.
All righty, pronounce that again? Rumor, okay. You are charged with public drunk. That bond is set at 1,000, and simple battery. That bond is set at 2,000. And you must stay away from Yanasha Copeland, and you must not violate any laws while out on bond. Do you understand the charges and special condition of your bond?
Yes, ma'am.
Do you wish to waive your preliminary hearing?
No, ma'am.
Okay, I'm gonna go ahead and put you down for 9/27 at 8:30 a.m. If you bond out, that date is automatically waived.
It's 3,000 total, right?
Yes, 3,000 total.
All right, thank you.
And it appears that you do qualify, you do qualify for a court-appointed attorney, so I have appointed one to you. Good luck to you, sir.
All right, thank you.
Okay. Hold on. Okay. All right, are you Mr. Donald Tucker?
No, ma'am. Sorry.
No. You can, what's your name?
Edward Samuel Whaley.
Okay, Mr. Welling, you're charged with following too closely. That bond is set at $500, and you must not violate any laws while out on bond. Do you wish to waive your preliminary hearing?
Yes, ma'am.
All right. You have refused a court-appointed attorney, correct?
Yes, ma'am.
All right. Good luck to you, sir.
Bring your name right there. That's all. Bring your name right here. Wilkerson. And then sign your name right there.
I didn't know I was able to make bond. Sorry, man. Thank you.
My name is Marion.
All right, Mr. Wilkerson, you're charged with battery. That bond is set at $2,500. Disruption of a public school. That bond is set at $3,500. And you too must stay away from Clint Polk, and you must not violate any laws while out on bond. I'm going to set your preliminary hearing date for 9/27 at 8:30 a.m.
And the total bond amount is what?
Your total bond is $6,000.
All right, thank you.
And I am gonna, I see where you put refuse a court-appointed attorney, but I'm gonna go ahead and assign you one. Once you get a new attorney, that attorney will file what we call an entry of appearance, and then that court-appointed attorney will be released.
Thank you.
If you bond out, that would waive your preliminary hearing. Like I told the other female, it's too early in your life to start getting racking up criminal charges, sir.
Yes, ma'am.
All right, good luck to you.
And Your Honor, are we still bringing up Woods?
I still have not gotten the, criminal histories, but I can go ahead and do the fugitive.
Yes, Your Honor. Mr. Clark, you come on up.
Mhm. And Ms. Thomas, can you contact the jail again and let them know we're still waiting on those criminal histories?
Yes, Your Honor.
Thank you. All right, good morning. Again, I'm Judge Paige Johnson, and this hearing is what we call an extradition hearing. A fugitive warrant has been issued for your arrest. You do not have charges pending against you here in Clayton County. Actually, I think you actually do, I believe.
I got a charge over there in the city of Morrow for driving infraction, but my time that I served, the time for the aggravated assaults, those were done on August 18th.
Hold on one second. All right. So for the hearing we're about to do right now, your pending charges are not what we're dealing with today, okay?
Okay,
So you have been brought to court today because you have charges pending in another state, and that state, which happens to be Maryland, is requesting that you are returned to answer to the charge of probation violation and possession of a firearm. In accordance with the laws of the state of Georgia, you are brought before me for an explanation of this proceeding. You have the right to contest the legality of this one in all extradition proceedings, or you may waive your right to the extradition proceedings and voluntarily be returned to the state that's requesting your detention. Before you inform me as to whether or not you wish to waive your extradition, let me explain the following rights to you. You have the right to be represented by an attorney. If you cannot afford an attorney, one will be appointed to represent you. If you desire to contest the legality of extradition proceedings, then you must file or have filed on your behalf a writ of habeas corpus. You will be allowed a reasonable amount of time to file this writ. You may file a writ of habeas corpus to contest the extradition. The writ of habeas corpus only contests whether the extradition documents are in order on its face, whether you are charged with a crime in a demanding state, whether you are the person named in the extradition, and whether you are in fact a fugitive. You cannot contest your guilt or innocence in this state. You are entitled to the advice and counsel of contesting extradition or in deciding whether or not to waive. If you waive extradition, the demanding state will have 30 days to pick you up. If they do not pick you up within that 30-day period, you will be released. If you contest extradition, if the state is unable to extradite you in 30 days, then you will be committed to the county for an additional, you may be committed to the county for an additional 60 days while you wait extradition. Do you wish to waive extradition and be returned to the state seeking your return, or do you wish to have a formal extradition proceeding?
I'm gonna waive.
You're gonna waive?
Yeah, I want him to come get me.
All right, and are you making this decision freely and voluntarily?
Yes, ma'am.
All right, the deputy is gonna have you sign a document.
Okay, I got one question, ma'am. You said possession of a firearm, violation of probation. I've already served the time on the possession of a firearm. I didn't get a firearm charge since I've been here. This is a violation.
Like I said, I can't really answer any questions related directly to,
Okay.
but I would say that on the warrant itself, it indicates probation violation is for the weapon offense.
Okay. And
Yeah.
are they gonna extradite me before I handle my case in the city of Moore?
Whenever they come, I'm not sure.
And if
They have 30 days to come.
okay, I just don't want to get another warrant over there because they gave me a failure to appear over there and put a bench warrant out for me. I've been sitting here for a year, and then when it was time for me to be released, a warrant for DUI, and they just reissued me a court date no second. So
I am not sure. Have you been appointed an attorney?
no, ma'am.
All righty, I will go ahead and appoint an attorney to you, all right?
Is that for the extra?
For the criminal case.
Okay. Yes, ma'am.
All righty, good luck to you.
All right, thank you. Yeah.
You can take a seat. And then, Your Honor, we're just gonna wait on the criminal history for.
Yes, hopefully they'll get it to me momentarily. Thank you. I'll be on hold.
Yes, I already pulled it. Thank you. Can someone call down for victims?
All right, we'll start. First off, will the attorneys please put their appearance on the record, please?
Taylor Fleming on behalf of the Office of the State Attorney.
Tyler Brands on behalf of the Public Defender.
All right, and then I do appoint the public defender to represent all of the defendants who are not represented by private counsel. All right, let's see, Ashley Nathan. And all right, Ms. Nathan, first off, you're out on bond in Orange County, but you also have now an out-of-county warrant, a bunch of them, from Brevard County. Since we don't know whether the warrants predate your bond or post-date it, I won't touch the bond that you have in Orange County because we don't have that information. We will notify Brevard County and the procedure to transport you there or not will take place. Is there anything else, State?
Does she have bond on the out-on-county warrants, Your Honor?
Let me check. Yes, thank you for asking. You have a $3,000 bail, but you have 1, 2, 3, 4, 5, 6, 7, 8, 9. It looks to be about 9 different warrants, each of them $3,000. So it's almost $30,000. All right. Anything else from anybody?
No, Your Honor.
Thank you very much. Right, we'll take no action on our bail and just let the other county know. Okay. Next would be Celine Aguilar. All right. Okay, next two are Spanishes. Okay. Okay, thank you.
Good morning, Your Honor. This is Laura Bretaña, certified Spanish interpreter, previously sworn.
All right, and have you been sworn in?
Yes, I have been sworn.
Okay, all right. For your documentation, the defendant's name is Selin, S-E-L-I-N. That's the first name. Middle name is Noel, N-O-E-L. And then the last name is Aguilar, A-G-U-I-L-A-R. And the, where's the case number on here?
It's out of county, Your Honor, so it's not
Yeah,
a standard.
this is out of county, so we don't have a case number. I'm not sure how you document that, but so, Mr. Aguilar, you've been picked up on a warrant, an out-of-county warrant. The warrant is from Miami-Dade. First off, let me verify. Are you hearing me, sir?
Yes.
Okay, good. All right, there's a warrant out of Miami-Dade. There's a no bond on that warrant, and so you will have to be transported to Miami. And in Miami, you will then address any bond issues or anything else relating to it. Anything else, State?
No, Your Honor.
Okay, and next we have, and translator, we do have one more, which is, this second one is Cesar, C-E-S-A-R, A like an apple, middle initial, and then the last name is probably run together because that's the system, but it's Gomez, I'm not sure how to say the last one. It's G-O-M-E-Z like in zebra, R-E-S-T-R-E-P-O. I guess it's Gomez Estrepo. All right.
Gomez Restrepo, Your Honor.
Okay, and this is a violation. Okay, we do have, okay, case number for Orange County is 2020 CT, that's Charlie Thomas, 2722, A like an apple and O like an orange. Sir, you are in custody for a misdemeanor, a violation of probation. There's not a bond situation for a VOP. We will notify them, and within about 5 days, you will be in front of the VOP court to address whatever the issues are and to resolve this matter, hopefully. All right. Anything else from the state?
No, Your Honor.
Next, we have Nancy Jane Miller.
I don't believe this is a Spanish interpreter case, Your Honor.
Okay, interpreter, we're done? Okay, I'm told we're done with interpreter cases, so thank you very much for your service.
Thank you, Your Honor.
Okay, and so counsel, if you will put your appearance on the record.
Good morning, Your Honor. I am David Redfern of Longwell Lawyers for Nancy Miller.
Okay.
Stands to my right.
Okay, Ms. Miller, you're here for violation of probation. For initial appearances, it's a felony violation of probation 2 times, and we don't do anything except refer it to the VOP court, and at the VOP court, which will be about 5 days from now, you will then address whatever issues there are. Was there anything else you needed today?
Your Honor, we did make an application for bail that was previously denied by Judge Wilson when she was out of state. She's been held in custody out of state for the past 30 days since August 14th. I understand the court's admonishment or statement just now, but I would like to make another last-ditch effort to adjust the bail to ROR. The prosecutor, Mr. Stokes, and I have agreed that ROR is a resolution that the state would recommend and that we would recommend, but I do understand the court's earlier statement.
Well, let me ask the state. What's your position?
Your Honor, I do have notes from the trial ASA, Mr. Stokes, regarding that he did speak to Mr. Redfern and does agree to ROR. So state has no objection to ROR, understanding that it is within your discretion as she's not entitled to bond. However, it is recommended by the state to ROR her.
Well,
And Your Honor, these were technical violations.
okay, that's what I was just looking for. What is the violation?
One is that she had not completed community service hours at the rate that was ordered, even though there is time, or there was time left on her probation to complete the hours, keeping in mind that this was during the pandemic era when community service was
Okay, what's the
disrupted.
next one?
And the other one was failure to pay the statutorily required $1,001 fine for this type of offense.
Okay, all right. So long as what I was really looking for, and you addressed it, is that it's not a new law violation.
Correct.
It's a technical violation. So with the agreement and consent of the state, we'll go ahead and release her ROR. You have a good attorney. I want you to stay in touch with them and make sure that, you know, that you do show up for the VOP hearing because this is really discretionary. And so I'm showing you respect, but I expect you to show up and take care of this, okay?
And thank you, Your Honor. And my expectation is that she will remain in the area until the next court date, which we hope is soon.
Yeah, I'm told that it's typically 5 days from now, but, you know, I don't know. Thank you very much.
Thank you, Your Honor. Thank you, Your Honor.
Okay, and next person is Delbert Henry. Mr. Henry.
I don't think it follows the same in jail, which is
All right, Mr. Henry.
Your Honor, may I have a moment to confer?
Yes, sir.
And Your Honor, just for the record, there was an offer conveyed to Mr. Henry of an adjudication of guilt, credit time served, and no returns to the Planet Fitness located at 4526 South Orange Blossom Trail.
Your Honor, I did have a chance to speak with Mr. Dilbert, or Mr. Henry, excuse me. Before court, we went over the state's offer. went over the plea form. I believe he wishes to resolve no contest. The plea form's coming to the bench now.
Okay, Mr. Henry, you heard what the attorneys just said. Do you accept the plea as being in your best interest?
Yes.
Okay, all right, Mr. Clerk, we'll go ahead and accept a no contest plea. We adjudicate. Time served is how much?
3 days.
3 days. Public defender services, $50. And then the clerk's fee is $273. And then, sir, you are to report to one of the courthouses and to either pay the money or to enter into a payment plan. It can be $10 a month, whatever the payment plan is, a payment plan. And so report to one of the courthouses and enter into a payment plan, presumably, and you have to do that within 30 days. If you do not do that, then your driver's license and motor vehicle registrations will be suspended until you pay the money. Do you understand that?
Yes.
All right, thank you very much.
And then, Your Honor, are you taking any action on his out on ROR case?
State would request no action due to pleading to this case, Your Honor.
I'm sorry, I couldn't quite understand.
State would request no action on his out on bond due to pleading to this case.
Okay, we'll take no action. All right, thank you, Mr. Henry. Okay, next is Marcus Robinson. Fine, Mr. Robinson, this is a violation of probation. You'll go to there's no bond in that situation, and you'll go to the VOP court within about 5 days and take care of whatever it is then. Thank you very much.
I believe Mr. Robinson's case is actually $2,000 on his VOP warrant.
Okay, let me check that. Okay, I see what you mean. I got it. Thank you. There is a bond of $2,000. And otherwise, everything else is the same. All right, thank you. Okay, and next is Robert Nickerson. Mr. Nickerson?
Refuse, Your Honor.
All right. We'll go ahead and...
Your Honor, we'll waive the appearance.
Right, it's a no bond situation, and we'll refer him to VOP court. Right.
Thank you, Your Honor.
Okay, next is Victor Toro, T-O-R-O. Okay. Okay, Mr. Toro, he is present, and so you have been picked up because of an alleged violation of probation. There is a no bond situation. In other words, there's no bond at this time, and you will go to the VOP court and take care of whatever this issue is at that time, and that's typically about 5 days from now. And so thank you very much.
Your Honor, he also has another warrant,
He does?
which is the basis for the VOP.
All right, let me look. Okay, I do see, okay. Sir, I see where you are also arrested for a felony, burglary of a conveyance, fraudulent use of a credit card, and criminal mischief, and petty theft. I don't see any others. And so at this point, we'll go ahead and well, it says no bond, probably because of the VOP.
He is entitled to bond on all 4 counts, Your Honor, so state would request reasonable bond on all 4.
Right, that's what I was just going to say. Thank you. So looking, well, I see where there's no felonies, 2 misdemeanors, no failures to appear. So since you don't have any real serious history.
You're looking at someone else's sheet, Your Honor.
I'm sorry?
Are you looking at Toro, Victor?
Oh, I'm sorry. I must, let me see. Oh, thank you. Let me go back and, all right, now, thank you. I do see you have 12 felonies, 12 felonies, 11 misdemeanors, 1 failure to appear, and there's 28 unknown. And so the burglary of a conveyance, we'll go ahead and do that at $10,000. Fraudulent use of a credit card, we'll do that at $2,500. And then criminal mischief, $1,000, and petty theft, $500. And sir, in relation to this, you are not to return to the scene of this incident. You're not to have contact with victims, co-defendants, witnesses. You are to remain drug-free. You are prohibited from having any firearms, ammunition, or other weapon. State, anything else?
No, Your Honor.
All right, thank you. Next, we have Andres Jesus. I'm sorry, Jesus Andre Plazas, Plazas.
Mental health, Your Honor.
I'm sorry?
Mental health.
Mental health, okay. All right, we'll set it over for tomorrow.
Your Honor, this is the 4th time.
We'll waive the appearance, Your Honor.
All right. Then, State, are any of these not entitled to bond?
Yes, count 1 and 2 are both capital offenses. Count 3 is a punishable by life offense. So on 1, 2, and 3, state would request no bond pending an Arthur hearing at a later time. And count 4 is an F2, which he is entitled to bond on, so state would request a reasonable bond.
All right, so Mr. Clerk, we'll go ahead and do the no bond on the first 3 counts, and then on the 4th count, we'll do that at $50,000. And then as a condition of bond, he is to have no contact with children, no contact, so generally the word children, no contact with the victim, witnesses, co-defendants, if any. He is to not have contact, not to return to the scene of the incident, and to be drug-free, and to not possess any firearms, ammunition, or weapons. Anything else from the state?
No, Your Honor.
And just for the record, he does have an immigration hold.
And, all right. Also, immigration hold for everybody's information. here's one more. No. Okay, next is Marcus Carey.
Yes, sir.
Mr. Carey, you're arrested for a felony. The first one is attempted armed burglary on an occupied dwelling, and I believe that's a no bond.
No, Your Honor, it's an F2 due to the attempt.
Okay, all right, and then aggravated stalking with a credible threat and criminal mischief, and then harassing communications. And so when I read this, I think this was not a gun, it was a knife.
Yes, Your Honor.
Right, this is right. So all right, we'll go ahead and what is the do you have in front of you the bond schedule for that first offense?
I think it comes in, Your Honor, as to be set.
How much?
First appearance, I don't think it comes in with a bond amount.
Okay.
However, it is an F2.
All right. All right, we'll go ahead and do $20,000 on count one, aggravated stalking with a credible threat, 10,000. Criminal mischief, we'll do that at 5,000. And then harassing communications at 1,000. And sir, you're to have no communications with this person. Now, I read the arresting affidavit, and she had asked you not to communicate with her, and so I'm just telling you, if you communicate with her as alleged that you've done in the past, then you will be arrested. So no communications means no communications.
Yes, sir.
Any way, shape, or form.
Yes, sir.
So no communications, do not go around her.
Yes, sir.
No contact, and you are to be drug-free, and you're prohibited from having any kind of weapon. So a firearm, ammunition, or weapon, in this instance, it's alleged that you possess a knife. So a weapon is anything that can hurt anybody else. So stay away from this lady.
Your Honor, state would request no return to George's Hideaway, which is one location in this affidavit, and no return to her apartment or place of residence.
Yes, so we'll put both. There's the cocktail lounge or bar or whatever it is.
George's Hideaway and residence.
What is it?
George's Hideaway.
George's Hideaway, and also the residence of the alleged victim. Okay. All right. Thank you very much. Okay. Next we have Ray Sean Padmore. Mr. Padmore. All right, Mr. Padmore, you're arrested for a felony. It's a battery, there's two charges. One's a battery, and the second one is aggravated battery causing bodily harm or disability. And, okay, let me look at his history. No felonies, no misdemeanors, no failures to appear. So on the battery, we'll go ahead and do that at 5,000, and then the aggravated battery, we'll do that at we'll do. I think I'm going to do it separate, different. The first count one, we'll do it 2,500, 2,500. And then count two, we'll do it 5,000. And so, sir, you're to have no contact with the victim, do not return, no contact with the victim, witnesses. Your attorney is the person to do that. And so no contact, no return, no drugs issued, no drugs, and no firearms, no weapons, ammunition, or firearms. State, anything else?
No, Your Honor, and for count 2, the AGBAT, great bodily harm or disability, I think it came through incorrectly. I believe the statute is correct. I believe it's an AGBAT with a deadly weapon, the motor vehicle, domestic violence. I just wanted the record clear.
Oh, okay. All right, were you suggesting a higher bond?
It's an F2, Your Honor. However, due to Mr. Padmore's lack of criminal history, I believe the bonds you set are sufficient with the standard DV conditions.
Okay. All right.
Your Honor, may I have a moment to confer as well? Thank you, Your Honor.
Your Honor, was a separate residences ordered?
Um,
It is a DV case,
Right.
and there was a child present, so state would ask that comply with
Okay.
DCF.
Yes. No contact, live at separate residence if that is applicable. So no contact, live at separate residences, and put, do you have a child with this lady?
I have 2.
Okay, no contact with the children, so put that in there. If you want contact with the children, you're going to have to ask a judge about it. This isn't appropriate today. So no contact with the lady, no contact with the children, don't go to their school, don't go there for lunch, all of these things that I see oftentimes. So no contact means no contact, or you're going to be back in jail. Do you understand? And so.
And Your Honor, may I have a one-time return with law enforcement, pick up any personal belongings?
Yes.
Thank you.
So we'll order that. Okay, anything else from anybody?
Your Honor, was there a comply with DCF? DCF was contacted.
Okay, DCF, I'm told, is involved, and so, my orders come first. And then you can comply with DCF, but if DCF sets up a visitation or who knows what, my orders stand. My orders are first. So sometimes I've seen where, well, DCF told me I can have visitation, and then they blow off what the judge says, and so that conflict occurs, and then someone winds up in jail because they have contact when DCF told, oh yeah, you can have contact, and so that's an issue. Okay, all right, next is DeQueria Spencer. Okay, Mr. Spencer, you're arrested for a felony, robbery, sudden snatching, battery, domestic violence, assault, domestic violence, petty theft, and then possession of drug paraphernalia. You have no felonies, 1 misdemeanor, no failures to appear, which is positive, but looking at this was the battery sudden snatching. Okay.
It was the victim's cell phone, Your Honor.
Say again?
It was the victim's cell phone.
The victim's?
It was the victim's cell phone.
Oh, so, okay. And was the victim like related, I think?
I believe they are girlfriends or ex-girlfriends.
Yeah, that's what I remember. All right. And so the nature of it was more an argument, and then it just got out of hand, and the snatching of the cell phone. So since, you know, people, you get a higher bail when you have an extensive criminal history. And so since you don't, I'll go ahead and leave the bail at $1,000 for count 1. the battery at 500, the assault at 250, the petty theft 100 is fine, possession of drug paraphernalia, the 100 is fine. And so, I've given you the amounts of money to get out of jail, but listen to me, no contact means no phone, no email, no nothing until all of this is over with. No contact, no return. Were y'all living together? No. Okay, and so you don't have any reason to go to that other person's place. All right, and then I want you drug-free, and so then also no firearms, no ammunition, and no weapons. State, anything else?
No, Your Honor.
All right, thank you very much.
Good.
Okay, next we have Dimitri or something like close to that, and Stafford, S-T-A-F-F, say again?
Behavior.
Behavior, all right, we'll set it over to tomorrow.
We'll waive, Your Honor.
Okay. Then he does have 3 felonies, 6 misdemeanors, so we'll go ahead and change the battery $1,000 to $2,500, and no contact, no return to the scene, and no drugs, and no firearm, ammunition, or weapons. And well, no, I'm gonna do no contact. So, thank you for that information. Okay, are you Mr. Suarez? Okay, Mr. Suarez, you're arrested for a felony. It's intimidation by sending a written threat to kill somebody. And then number 2 is damage to property, criminal mischief. And then number 3 is battery, and that's all I'm aware of. And I do see, let me look here, you were arrested on a warrant. And so count 1 and 2, the judge that issued the warrant, we have to respect their amount of money, so we won't change that. Count 3, he put none, which is, I can override that. And so we'll go ahead and put...
Your Honor, just for the record, count 1, that is, it's currently set at $500, is an F2. Count 2, which is an F3, is currently also set at $500. Count 3 is the M1. However, there were several threats made within the affidavit, and Mr. Suarez does have at least 2 prior about DVs. I believe both of the victims being his mother, which is a different victim than this instant case. Probably state would ask that you take that into account when setting his bond.
Okay.
I believe one of the threats he made, that he's not afraid to go back to jail, so states concerned regarding the victim's safety if he does violate.
All right. All right. What's your recommendation on count 3?
Your Honor, state would ask for 1,000.
All right. So we'll order the $1,000, but no contact. I know this is your mother, right?
No, Your Honor. The 2 prior DV cases were his mother.
Oh,
This
the
case
2
is a
priors
girlfriend
were
or
his mother. Okay. So this person's relationship,
it's a girlfriend, Your Honor.
girlfriend. Okay. All right. So no contact. All right, no contact. Were you and she living together? Were you and she living together? Okay. So you don't have anything at her place. Okay. So no contact, and that means no way, shape, or form. No email, no love letters, no flowers. I remember we did have one where the guy sent flowers, and he said, "I apologize for beating you up." And so he said, "I sent her flowers." And I said, "No, and that's still contact." So no flowers, and so no contact with her at all, no return to the premises or the scene of the incident, wherever she lives, and no drugs, no firearm, ammunition, or weapon. Anything else, State?
No, Your Honor.
The other 2 stay out there because another judge issued that. Okay, William Henry?
Yes, sir.
Okay, Mr. Henry, you're arrested for a misdemeanor, conditional release violation, and release. So is this over in the VOP court?
No, Your Honor. I believe we saw Mr. Henry a few days ago for a burg. I think it was a burg conveyance and a petty theft, or no, burg conveyance and a domestic violence. One of the conditions you set was no contact. I believe it is alleged he called the victim from the jail and left a voicemail for her in violation of the no contact order Your Honor placed.
Okay.
I believe on the 13th, so earlier this week.
Okay. All right. We'll go ahead and put $1,000. Let me look at $1,000 bail, and so $1,000 is going to cost you $100 with a bail company with $1,000 bail. So the bail is $1,000. No contact means no contact. Any reason she doesn't want to hear from you, and you don't want to call her because you're going to be back in jail. And if I see you a 3rd time, it's going to be a big bail. So in other words, I'm a little annoyed that this time you're back so soon after I told you no contact. And so a 3rd time will not be in your best interest. So no contact, no return, leave this lady alone, and you are to stay drug-free and to possess no weapon, ammunition, or firearm. State, do you have any other information, anything else?
No, Your Honor. Just for the record, if he is back, State will be requesting no bond.
Okay, thank you very much. Next case.
Give us a call.
Your Honor, can you skip over Cassandra Jackson?
Okay, let me set that aside. Tell me when you want me to call it up. Okay, next is Jennifer Magder, M-A-D, okay. How do you say your last name?
Madrigal.
Okay, can you pull the microphone? Yes, thank you.
Madrigal.
Okay, you say it much better than me. I could never say it. Thank you. Okay, we don't, for the record, we don't have anybody in the audience to speak to this. This is a misdemeanor and a battery, domestic violence.
And she does qualify for PTR, Your Honor.
She does?
Yes.
The state has no objection with standard, no domestic violence conditions.
Okay, we'll go ahead and release her, pretrial release with domestic violence conditions, which are no contact with the person. Were you living with this person?
Yeah, so I'm visiting from Chicago. We came for a vacation.
Okay, do you have like luggage and clothing at her
Yes.
place?
At the hotel, yes.
Okay, so you can go there with a sheriff's deputy one time and get all of your stuff. And you said you're from Chicago?
Yes.
Okay, and I give you permission to return to Chicago, provided that you cooperate with your attorney, whether it's the public defender or someone else, and you take care of this case. If you don't take care of it, if you go missing, then a warrant will be issued and you'll be arrested in Chicago and transported down here and all of that. So, so I don't know of any reason, you don't have any history that I'm aware of, and so just take care of this, okay? Okay, and you are prohibited, no contact with the alleged victim, no return to the scene except to get your stuff like I've already explained, and no firearms, no ammunition, no weapons. You understand me?
Yes, Your
Okay,
Honor.
state anything else?
No, Judge.
All right, thank you very much.
I have a moment, Your Honor.
Yes.
Your Honor, would she be allowed another one-time return with law enforcement in Illinois to collect any personal belongings as well? They live together in Illinois.
Oh, okay. Yes.
So one for the hotel and one for residents in Illinois?
Yeah.
Thank you, Your Honor.
Okay. You know, one thing, you know, ma'am, yeah, you know, one thing I've learned is relationships, you know, hopefully relationships start up here, really high, wonderful, he's the most wonderful man I've ever met. And then after you get to know each other, all relationships go downhill, and then they sort of level off. So they go from here, down here, and level off. And then that's the person, the real person. And so water doesn't run uphill, and relationships don't get better. So they will go down to where in the middle, and then that's who you're going to be with long term. And if that isn't good, get out of the relationship. I've had 2 women murdered in my career as a judge, and every day in Florida, several women are murdered, and they're all murdered by their boyfriend, the guy they chose to date, that chose to marry, and that person is the one who murders you. And so you seem like a nice person, you responded appropriately, and so I tell you as a judge that's done, I've been a judge for almost 27 years, and so take care of yourself first. And so, okay, I wish you well.
Thank you, Your Honor.
Okay, and next we have Philip Walker. Mr. Walker. Okay, and what is this victim? Oh. Okay, Mr. Walker, you've been arrested for battery and the person involved in this incident does not want you to contact them at all and want to be informed, which they will be anyway, about this case. And so looking at who you do have 5 felonies, 25 misdemeanors, 1 failure to appear, and then the description goes for 2 pages. And so, State, were you going to say something?
Yeah, Sean, State was just going to bring to your attention, Mr. Walker has pretty extensive.
Can you speak into the microphone?
State was just going to bring to your attention that he has a pretty extensive BAT DV history. He currently has an open 2021 misdemeanor non-arrest BAT DV of Mr. Walker, his father. He has a 2021 non-arrest felony battery on a person 65 years or older. Also, victim being his father, Mr. Walker. Another 2021 CF battery on a person 65 years or older, his father. A 2020 battery on his father. A 2019 misdemeanor non-arrest battery. 2019, 2019, 2018, 2016, 2014, 2012. It seems to be a pretty extensive battery history, Your Honor, of different victims. So it was just bringing that to your attention when setting his bond.
Okay. We'll go ahead, and this is a misdemeanor, but I'll increase the bond bail amount because of his 25 misdemeanors, many of which were just referenced, and then 5 felonies. We'll go ahead and change that to be $2,500. So $2,500. No contact with the victim or witnesses, no return to the scene of this incident, and no weapons, ammunition, or firearms. Anything else, State?
Your Honor, State would also ask for no drugs or alcohol. I believe it is alleged that Mr. Walker was intoxicated.
Okay. No alcohol, no drugs, and it is troubling that you've been arrested so many times, and for similar situation, that I do want him drug tested after 30 days. So we'll give you 30 days to get your system clean, and then after that, you will be drug tested each month, randomly drug tested each month. And if you are positive, you're going to be right back in jail. And so that will continue until this case is disposed of. All right, anything else?
Your Honor, I believe he also was living at that location.
Oh,
I believe
okay.
he might need a one-time return.
You need to return there to get some stuff?
Yes, sir.
No? Okay, he says.
He said yes.
Said yes.
Oh, he said yes? Oh, okay.
Sir.
All right, sir, you can call law enforcement to accompany you to go there, so make sure there's no problems and get your stuff. Now, and that means your clothing and any work tools, that sort of thing.
Yes, sir.
All right, thank you very much.
Your Honor, this is Jackson Cassandra.
Okay, thank you. All right, next we have Cassandra Jackson. All right, Ms. Jackson, let me look at what this is. You've been arrested for a misdemeanor, and it's a domestic violence battery. looking at who you are, and let's see, 0 felonies, 0 misdemeanors, 0 failures to appear. There's really nothing else. So, with any reason, I would go ahead and, did she qualify for pretrial release?
She does not, Your Honor.
Oh, why?
She had not been positively identified, and she was not interviewed prior to court.
Okay. So let's go ahead. Now, Ms. Jackson, has she now been fingerprinted and identified?
She has been, Your Honor. I'm trying to pull up her history now to see if there's anything new to add.
Well, maybe we ought to just bring her back tomorrow when we know who she is.
Well, we have identified her now, Your Honor.
We have identified her? Okay, you just haven't run a background or something?
Right, that's correct. We ran it by her demographics, but not by her fingerprints.
All right, well, let's do it this way. All right, if you qualify for pretrial release, then you can be released pretrial domestic violence conditions. If not, then we'll go ahead and put $1,000 as a bond. So $1,000 and so no contact with the victim, no return to the place of residence. But were you living at that place where you were arrested?
I'm on the lease.
You're on the lease?
Yes.
Okay. But because of this incident, you're going to have to go live somewhere else, even though you're on the lease. So get your clothing. I'm not talking about moving furniture. But people sometimes will go there and they want to move furniture, refrigerators. No, you don't do that. You'll just figure that out later. You get your clothing, your personal items of that nature, any work-related tools or uniforms, and then you go live somewhere else for a period of time, and then eventually all the rest of the stuff can be divided. So you have no contact, no return except as I just described, no drugs, no firearms, ammunition, or weapons. State, anything else?
Your Honor, I don't believe it was explained that the return is with law enforcement.
Yes, if I didn't say that, if I failed to say that, it is you call law enforcement and they know the routine and they'll go with you to get your stuff. Don't go there yourself. The history of doing that is very bad. People really get into a lot of fights and arguments and even die because of problems. So we're trying to help you do the right thing, okay? So stay away from this problem and just stay away and and work with your attorney. Thank you very much.
And then, Your Honor, do you want her to have a choice, bond or PTR, or if she qualifies for PTR, you want her PTR?
No, if she can qualify and not have to spend that money,
okay,
that's preference.
Okay.
But if she doesn't, I had someone in front of me for a misdemeanor, and then when they checked him, they were wanted for murder in California. And so you never know who you're dealing with. Okay. Hector Campo, I guess it is, Campos, P-O-S, Lopez.
He's downtown court, Your Honor.
I'm sorry?
He's downtown court.
Oh, downtown court, okay. All right, we'll bring him tomorrow.
We'll waive the appearance, Your Honor.
Okay. All right, this is out-of-county warrant. It's $1,000 bond or bail, really. And it's Osceola County. We'll notify them that he's in our custody for them to come and get him.
And Your Honor, he did have a first appearance detainer added for an open case he has here in Orange County. It's for 2022 CF 0000250 AO. It's a possession of cocaine.
Okay, I don't have that.
I believe that's potentially the case he's downtown court for. It's set to plea today.
It is, they didn't put the FAD when he came back in August.
Okay.
We had to add it now.
Okay, so do we need to put that on the docket for tomorrow?
No, you can address it today, Your Honor. If you want to take any action or no action, it's up to you.
Well, State, can you help me?
Your Honor, it appears he's downtown court for a set to plea in Judge Harris's courtroom, which is probably why he's not here today.
Okay. All right, then, so really, it sounds like I don't need to do anything.
No, Your Honors.
Okay, all right, thank you very much. Okay, next we have Jamie Pelletier.
Yes, sir.
All right, Ms. Pelletier, you have a warrant out of Seminole County, and they have it as no bond, and so there's there's 1, 2, 3, 4, looks to be 4 different warrants, in other words, 4 different cases in Seminole County. We will notify them that you are in our custody, and they will make arrangements to take you to Seminole at the appropriate time. All right, thank you very much. Okay, next is Adriana Rivera.
Yes, sir.
All right, Ms. Rivera, you're, okay, a violation of probation. There's an out-of-county warrant from Seminole County. So we will notify Seminole, and they will transport you there.
It's no bond, Your Honor?
I was just looking, no, I don't see a bond. There's, everything says no bond. Okay, and next is Virginia Webb. Virginia Webb. Okay, Ms. Webb, we have an out-of-county warrant. It's a no bond. Out-of-county warrants, another one, no bond. They're both out of Volusia County. We will notify Volusia that you're in our jail, and arrangements will be made most likely to send you to Volusia. Thank you very much. Next is, should be Robert Bailey.
Yes,
Mr. Bailey. All right, we have Orange County violation of probation, and it looks like there's 1, 2, 3, 4, 5, so 5 different VOPs, and there's no bond on any of them, and so you'll go to the VOP court and deal with those 5 violations. All right, thank you very much, sir.
Yes, ma'am.
Okay, and then Terrence Baker.
Yes, sir.
Okay, Mr. Baker, you're arrested for a felony, and it's related to a violation of probation. And it looks like there may be more than one, so let me look at this paperwork. No, that was just another piece of paper. Okay, looks like I have 1 VOP. It's Orange County. It's no bond. And so you'll go to the VOP court probably within the next 5 days, okay? All right, see you then. Okay, next is Mr. Bowman. Mr. Bowman, you're picked up for a violation of probation. It's Orange County. The judge that issued that warrant or that pickup order did a bond of $2,500. So you can either do the bond or wait about 5 days and go to VOP court to deal with it, okay? So,
Question, Your Honor.
yes, sir.
Because I was trying to bond out yesterday, and they said that according to what the bail bond said, that I have a hold.
That I don't know. Does anybody?
He has reporting requirements, Your Honor, so he has to come before initial appearance. That'll be closed now that he's here.
Okay, it'll be closed, so you can get a
He has
bond
reporting
now.
requirements.
Yeah, so you should be able to bond out today.
All right.
Okay. Okay, and next is Broken Brock. Okay, and I apologize if I said that wrong. You're in custody because of an alleged violation of probation. It's here in Orange County. It's a no bond situation. And so within about 5 days, you'll go to the VOP court and address that, whatever that allegation is, okay?
Yes, sir.
Thank you. Okay, next
Morning, Your Honor.
is, good morning, Centra Garcia.
Yes, sir.
Okay, did I say it right?
Centron Garcia, yes, Your Honor.
Okay, thank you. All right, you're here for VOP. It's a no bond situation. It is in Orange County, which means that probably within 5 days, you'll be in front of the VOP court to address whatever the allegations are. Okay, thank you very much.
I have a question, Your Honor.
Yes, sir.
My VOP, I'm in drug court. That's what the VOP is. There's no way I could get a bond, so I go to work.
No, let me, first off.
6 kids at the house, you know what I mean?
Yeah, well, but yeah, I was a drug court judge for 3 years, and so I'm very familiar with it, and I do support it, support the concept, and so at this point, I really don't have enough information to be able to do that, and the normal routine is it's no bond. I do see, here's a possession of cocaine allegation as a violation, also a fleeing and attempting to elude with lights. So the answer would be no. You're going to have to deal with that. All right, thank you very much. Okay, next is Mr. Georges.
Yes, sir.
Okay, Mr. Georges, there's an alleged violation of probation. It's a no bond situation. My paperwork doesn't say what county. Is it Orange County?
Sorry, excuse me.
Walton?
I'm sorry. What county? Oh, Walter. Walton, that's right. I knew we didn't have a Walter because I know all the counties. Walton County. And so we will notify them and see if they want to transport you up there. And typically there's a, what is it? I don't remember. What is it? How many days do they have? Does anybody remember? Anyway, I don't remember, but it's several days.
Is there a bond amount on that Walton County
No.
warrant? No. Excuse me, sir.
No.
And it appears he has a warrant from Walton and then an on view, I believe also for the same case. So you're setting both at no bond?
Okay, all right. Oh, there it is, Walton. Okay. We'll just notify Walton, please. And next we have, there that goes. There. Next we have Gonzalez Perez.
Your Honor, may our client be heard for a moment?
Yes.
On the Walton County case, or the Walton County warrant?
Okay, sir, the warrant states that, you feel me, when I come into the
judge, and on the first appearance, I should be able to get a bond. The VOP that's there, it wasn't, I mean, I went to my probation officer yesterday, I seen him, he said it was an out-of-county warrant from a DR caught in prison, and they said the bond was to be set at first appearance so that I can bond up. My baby shower is in literally a week, literally.
Well, okay, look, let's see. Okay, it is, I'm looking at an email, or I guess, or whatever this is called. It's not really an email. It looks like,
What, a teletype?
teletype. I didn't even know they still had that. But here's a teletype from Walton County. It says, warrant is active for possession of controlled substance, hold for first appearance. And so, state that seems to suggest that I have that they're giving me the authority to set a bond, set a bail, I mean.
Your Honor, state doesn't receive any other information, since it's Walton, I don't have any access to anything other than arrest affidavit, which says the charges. It being a VOP, he's not entitled to a bond. And I don't have any additional information about the case or the allegations or why he was on probation. I have nothing. And he's not entitled to a bond at this time, so I have no further information, Your Honor.
Your Honor, the warrant you're reading, is that for an alleged violation of the possession, or excuse me, not a violation,
See,
alleged
possession of
contraband or controlled substance?
There's contraband, and then there's possession of contraband. Both of them are contraband. Is there a third one?
No, Your Honor.
I tell you, I'll go ahead and interpret, to hold for first appearance would be me. So possession of contraband, we'll go ahead and put the bail at, we'll put this, what is cellular phone? Contraband?
I'm assuming he was in DOC or jail and had a phone, which he was not allowed to have. He had contraband while in custody.
Oh, okay, now I'm beginning to understand the context. Is there anything else outstanding on him?
Well, he's also in on a VOP, and it does look like it is for an Orange County case. So he's an on-view VOP in Orange County as well.
Orange County VOP, state, do you see that?
Yeah, sure. That's the two cases. One's orange and one.
One's orange, yeah.
Okay.
There's two.
All right, well, that's just too many VOPs. I'm going to deny a bail just because.
Your Honor, May has one more moment to speak.
Yes.
This possession of contraband is what caused the VOP. I have done nothing literally in the past 10 years. Just the possession of cell phone from prison. We've been 6 months now. After this happened in 2018, I was incarcerated the whole time.
Okay, well, let me just read this.
It appears that the Orange County case is a burg structure, grand theft third degree, criminal mischief, and resisting without.
All right, so that's more than just the contraband issue.
That was the underlying Orange County case, Your Honor.
Okay, that was the
There's a
underlying.
VOP on now.
Okay, and then is the VOP, because it's not clear, is the VOP here because of the Walton County contraband?
I do not know.
And I can't tell that either.
Which is why this is usually sorted out by the VOP court, because they get additional.
Well, okay, I'm going to deny a bail at this time. The VOP court can figure out what's going on here. Thank you very much. There's
I believe it's set for in jail VOP on the 19th.
the 19th, all right, the 19th. Okay, all right. Gonzalez Lopez? No, Gonzalez Perez? Is this the right one? Okay. All right. Okay, sir, this is a violation of probation. It's a no bond situation. It is Orange County, and you will go to that court within the next few days. All right, thank you.
Your Honor, there's 3 cases.
Oh, okay, let me.
There's, I believe, 2,
Okay.
1 VOP, 1 warrant, and 1 new law.
Your Honor.
Okay.
May defense be heard on case 2022 CF 8351?
351, okay, let me get to 351. Okay, here's 351. It's fleeing, attempting to elude. What do you wish to say?
Your Honor, as to probable cause, I know there's an affidavit to issue a warrant on the clerk's site, but there are no facts as to establish probable cause. It's merely
Because it's already been filed.
and then even with the information, there are no facts to establish probable cause. So I'm wondering where the probable cause affidavit would be found. Because without those facts, I can't.
Okay,
I wouldn't be able to find probable cause without facts establishing that, so that an information can be filed or a warrant.
Okay, let me, I have, okay, I do have, it says warrant arrest affidavit, and you read that?
Yes, Your Honor, but it's more so conclusory than setting facts that establish a charge.
Okay,
The
right.
reason that's not on the clerk's site, Your Honor, is because the information has been filed, a fleeing, attempting to elude, and a dwellis. And given that it's not filed, or given that it's filed and there hasn't been a demand, that's why defense has no access to anything, because it has been filed. State can put a factual basis on the record if Your Honor needs it, but probable cause has already been found as it is a warrant.
Okay, so I think you just said that there's been an information already filed?
Yes.
So then they just need to challenge the information, not the arrest. In other words, a motion to dismiss. In other words, the information, the proper challenge for probable cause would be against the information, not today. Is that what you're saying?
I'm saying that information's been filed, which is why he doesn't have access to anything, but probable cause has already been found.
Already been found. That's what I was trying to say. Yeah, it's already established unless you file a motion to dismiss that that information. But probable cause been already found. Yeah.
I understand, Your Honor, but on July 18th, there was an affidavit to issue a warrant with no facts as to the probable cause there, and then an information was filed on August 24th. So as to the warrant for the arrest, I would say there's no facts to establish probable cause, and I understand we can challenge the information as to the charges, but
There is a warrant with facts. You just don't have access to it.
okay.
Do you want it?
Why not? Yes, sure.
I mean, you have to give it back to me. You can't keep it.
Okay, the clerk just there is a warrant supporting, it's several pages long.
May I approach, Your Honor, to examine?
Yeah, you're welcome to it, so you have it. Do you want to keep it? Yeah, okay.
Your Honor, he's not supposed to keep it, and information's been filed. They had to file a demand to get, he's not supposed to keep it.
Well, all right. Okay, we'll go ahead and, all right, now, let's go ahead and, okay, Now, the one that is talking about 351, fleeing, attempting to elude, and state your recommendation as far as bail.
Your Honor, given that it's been filed, he'll need bonds on count 1 and 2, the fleeing and attempting to elude with license sirens activated, which is an F3, and a dwellless second subsequent offense, which is an M1. The allegations within the warrant are not incredibly egregious. However, Mr. Gonzalez-Perez does have a decent amount of criminal history and at least 4 prior failures to appear. So the state would ask for $5,000 on the fleeing and $500 on the dwellless.
All right. Okay. The fleeing and attempting to elude, which is case number 351, will do the $5,000. And then on the case that ends in 750, we have trafficking and the trafficking in fentanyl, and it already has a bond of $100,000, and we'll leave that as is. Possession of fentanyl, $1,000, and then possession of controlled substance, $7,500. Possession of a weapon by a convicted felon,
Or the weapons are knives.
okay, that's where I could, okay. All right. And possession of a weapon, we'll leave it as is. Possession of a weapon by a convicted felon, we'll leave as is, which is $1,000. So, all right, and then we have a VOP here in Orange, which is case 939, and we'll leave that as is, with no bond.
Are there any conditions on the trafficking case, Your Honor? No drugs, no weapons?
Yes. No contact with the victim or the alleged co-defendants, and no return to the scene, and no weapons, ammunition, or firearms. Anything else requested by the state?
No, Your Honor.
All right, thank you very much. Is this something? Where's this? Oh, this is the, okay, there we go. Okay, then we have Lori Zuzmuk.
Smuts, sir.
How do you say that?
Smuts.
Okay. We have violation of probation. It's a no bond situation. It is Orange County. So you'll be going to a VOP court within 5 days or so to address whatever those issues are, okay?
Yes, sir.
Thank you.
And
Thank
she
you.
does have reporting requirements.
Say again?
She has reporting requirements.
She has a,
Reporting requirements, Your Honor.
I don't. what-
Reporting, she has to report her change of address when she gets out of here.
Oh, okay. All right, do you understand?
What do you mean change of address? I didn't move. I'm confused.
Once you come to the, she's HRSO, so once she comes here, her address changes to the jail. So once she gets out, she needs to update that.
Oh, okay.
Oh, okay.
Thank you.
All right. Next is Weaver. Okay, Mr. Weaver, this is a felony, it's a violation of probation, it's a no bond situation, and Orange County. So you'll see the VOP court in the next several days. All right, thank you very much.
Your Honor, I spoke with Mr. Weaver as a friend of the court. He has a counsel, and he informed me that counsel filed a motion, but was unable to attend IAs today. Is there a motion in the system or a confirmation that there was a motion filed?
Okay, can someone print the motion?
I see that there was a motion to set aside or quash the capias. Your Honor, he does have VOP arraignment on the 19th as well, so within 3 days. State would argue that that's the best time to hear the motion to quash this VOP capias.
All right. Out of curiosity, I want to. Well, it's more an excuse for the violation. It says of COVID-19, and it goes into addresses, and it's more of an excuse. So I'm not gonna rule on it because I don't want to address the excuse that will be offered. And so that'll be taken up at the VOP hearing. There's always the excuse, and then there's the reason. And that looks to be the excuse or reason, I don't know which. Okay, thank you very much, sir. All right, do we have 33 days? Okay. Okay, 33-day motions. Let's see, Alexis with the last three of 537.
Granted, notice of non-filing.
Cesario Kulu or something like that. CESARIOCUCUL.
Your Honor, can we move that one to second session?
Say again?
Can we move that one to second session?
Oh, okay. Second session. We're going to do that second session. Okay. All right. Birch, BURCH. Last is 524.
Granted, notice of non-filing.
Then we have Robinson. Last is 397.
Denied, it's premature. Defendant only has 14 days credit.
Schmidt, 534.
Granted, notice of non-filing.
Okay, Price, 9420.
Granted, notice of non-filing.
Clayton, 585.
Granted, notice and on filing.
Pierre, 589.
Denied and information was filed.
Camacho, 494.
Granted, notice and on filing.
Smith, Jr., 8590.
You said eight, I'm sorry?
Let's see.
8570?
8570.
Granted, notice and on filing.
Okay, Soto and 9503.
Denied and information was filed.
It's AIME, AME, and it's 9504.
Denied and information was filed.
Garcia, 9511.
Granted, notice and on filing.
And that's the end. Okay, anything else from the clerks? Okay. All right, the clerks say that's the end. And now let's talk about session 2. We can do it early, but everybody has to agree. Corrections, clerks, attorneys. So we can do it at noon, we can do it at 1. It's up to you. What does everybody want to do?
State only needs an hour.
Yeah.
Corrections.
Noon is fine for us.
Is noon good for you?
Tyler?
Okay, noon's good for corrections. Does anybody have a conflict? And all you have to say is, no, it's not good for me. So it's up to you guys. Clerks, are you good with noon? The clerks are good with noon.
Noon's fine, Your Honor.
Everybody? All right, we'll see you at noon. Okay, anything else? Okay, I will see you at noon. All right, we have the same attorneys, and just for the record, I do appoint the public defender to represent those defendants that are not represented by private counsel. And so I was just told the first two are Spanish, so we'll get the translator on the line, and let's bring in Marvin Lopez. Yes.
Sí.
Let me ask you.
Good morning, this is Dalia Romero, Spanish interpreter on the line, already sworn in today.
All right, good afternoon, this is Judge McDonald. And,
Good afternoon, Your Honor.
And we, for your record, I have Marvin, let's see, Marvin. Last name is Lopez. I guess that's a hyphen in there.
Sí.
Yes.
Okay, so would you check with the defendant and see if he can hear you and go ahead, please.
Sí, poquito ese güey.
Yes, he can hear the interpreter a little bit.
Okay, all right. He's been arrested for two vehicle moving violations, and
Sí.
Yes.
And let me try to find. Okay, one is a DUI, unlawful blood alcohol, and it was 0.15 or higher is just the law. And then the second one is moving traffic violation, operating a motor vehicle without a valid license.
Okay.
Okay.
I'm looking at his criminal history, and he does not have any. And so you have a bail of $500 on each of those charges. Sir, you are prohibited from, as a condition of your bail, you are prohibited from driving. And so you need to get a friend, do an Uber, ride a bicycle, walk, whatever, but do not drive. Because if you drive again and we see you again, it's going to be much more expensive to get out of jail. Do you understand that?
Okay.
And so,
Okay.
And so as a condition, if you post your bail, then no driving,
Okay.
And so anything else from the state?
No, Your Honor.
Any other condition? Okay. All right. Let me, that is it. Thank you very much.
Bueno.
Very well.
Okay, the next person, for your record.
Good morning, sir.
It's a Daniel, Daniel. Coppin. See, these names run together. That's what makes it sometimes difficult to read. Coppin Rodriguez. I'll spell it for you so you can write it down properly. Coppingger, I think that's one word, and then Rodriguez. I think that's Rodriguez. And then the case number is 2022-CF Charlie Frank 10768 Alpha Orlando. Okay, sir, you are arrested for a felony. It's aggravated assault with a deadly weapon. And
En ningún momento nosotros discutimos verbalmente, de palabra.
At no time. We just had a verbal argument.
okay, that'll be determined. So at this point, my job is to tell you why you're arrested and to appoint the public defender. Now, the weapon is a box knife that supposedly you assaulted the victim with a utility knife. That's the allegations against you. Looking, let me see. Were we able to run, because his criminal history has nothing on it. Were we not? Okay, now I've got an updated sheet, and you do not have any felonies or misdemeanors or failures to appear. So in other words, you have no criminal history. That's good. And so let me just check one more thing. Okay, the bail amount set is $2,500. You are not to, now that's the amount of money. So the conditions are do not contact this person, the victim, any witnesses. You have a very good attorney. The public defender's office is excellent. They do an excellent job. They have very good attorneys. And so they are to contact any people that you feel should be contacted to build your defense. So no contact yourself. You work through your lawyer. Second, do not go back to the scene of this incident, and do not use any drugs, illegal drugs. Next, do not possess a firearm, ammunition, or any kind of weapon. So don't carry a knife. And so, do you understand everything?
Okay, no va a haber problema, no va a haber problema, correcto.
Okay.
Okay, there won't be any problems, correct?
All right, you look to be a good person who got into a bad situation, so I don't want you to make it worse, okay? Okay, well, good luck. Thank you.
Okay, thank you, sir.
Thank you, sir.
Okay, I think that's it. Yes, okay, translator, I want to thank you for your service. We always appreciate it. Without you, it would be very difficult to...
You're very welcome, Your Honor. Nice to see you again.
Thank you. Okay, and next we have Hugh Eubanks. His wheelchair? No. Oh, okay. Okay, Mr. Eubanks, you've been arrested for a misdemeanor, trespass on property after warning, and...
Your Honor, state did convey an offer to Mr. Eubanks of an adjudication of guilt, credit time served, and no return to 728 Spring West Road.
Your Honor, I did have a chance to speak with Mr. Eubanks before court, went over the state's offer, but I believe he has some defenses He informed me he has an address where he gets mail, and he's assured me that he'll meet with us, visit our office, call us to make sure he does not miss any court dates. We would request ROR at this time.
Okay, let me look at, you do have 1 felony, 6 misdemeanors, no failures to appear. State, I meant pretrial release. When you've looked at his history, does he qualify to be released on his own signature?
Your Honor, state would object to ROR, given that he does have a criminal history. He's a multi-state offender in Florida and out of state. So state doesn't believe that he is a candidate for ROR. The state's unsure if he would qualify for PTR, as I don't.
Didn't qualify him for PTR, Your Honor.
Okay, doesn't qualify.
But Your Honor, it is a trespass charge. It's not a violent offense, a victim of person or property.
Okay.
However, he does have multiple arrests and convictions of violent offenses.
Okay, we'll go ahead and, since he does have history, we'll change the bail from 500 to 1,000. And so, $1,000 is the bail, and you are to not contact any co-defendant, any victim, any witness. You are not to return to the scene of this incident, and you are not to take any drugs and not to use any, and not to possess any firearm, ammunition, or weapon. Anything else, State?
No, Your Honor.
All right, thank you very much. Okay, next would be Jennifer Lamar. All right, Ms. Lamar. Okay. You are arrested for a misdemeanor of petty theft. And looking at this, you do have 1 felony, 23 misdemeanors, 2 failures to appear. State, your thoughts?
The state doesn't have an offer this time, as it may be enhanceable, so state would just ask that you stay the bond instead of no return.
All right.
Your Honor, the alleged item was worth $1.49, so I'd have you consider that as well. She's unemployed and may not be able to afford a high bond. I would suggest a $100 bond on this.
All right. All right, we'll leave the bond at the $500. And ma'am, you are not to contact any of the victims, any witnesses, any co-defendants, if any. You are to cooperate. Your attorneys will do that if necessary. Do not return to the scene of this incident, and you are not to take any illegal drugs, and do not possess a firearm, ammunition, or any kind of weapon.
Yes, sir.
Thank you very much.
Your Honor, may I have a moment with this next client?
Yes, yes.
Just a moment, Your Honor, to fill out a plea form for Mr. Charles.
Okay.
I also spoke with him as a friend of the court, Your Honor, so there's no need to appoint.
Okay.
Plea form's approaching the bench, Your Honor.
Okay, if you'll state the plea.
It'd be a no contest plea, Your Honor?
And the offer conveyed to Mr. Charles for the resisting without is an adjudication, credit time served,
No return.
Okay.
and a no return.
All right. Okay, Mr. Charles, do you, you heard what the attorney said as far as a resolution for this case? Do you accept that to be in your best interest?
Yes, sir.
All right, and so, Madam, Mr. Clerk, we'll go ahead and do a no contest plea, adjudication, time served, how much?
2 days.
2 days.
1 day, I'm sorry, 1 day.
Oh, 1 day? Okay, 1 day. The court cost is $273, and you are to, after you are released, you are to go to one of the courthouses in Orange County and either pay in full the amount due or enter into a payment plan with the clerk's office. This can be done, this must be done within 30 days from the date of your release, or your driver's license and vehicle registrations, if any, will be suspended until you pay the money. Do you understand?
Yes, sir.
All right, thank you very much. Next week.
Jimmy Christian bonded.
Oh, okay. Jimmy Christian bonded.
And Sabrina Mixon is behavior.
Okay.
We'll waive the appearance, Your Honor.
All right. Okay. First off, we're speaking about Sabrina Mixon, M-I-X-S-O-N. She's out on bond already for leaving the scene of a crash with property damage. We revoke that bond and double it, which would be $1,000. And so, and that is case that ends in 6316.
3146?
No, I'm sorry. Initial appearance, Judge. No. It says,
He has two out on bond cases, Your Honor.
yeah. But both of them have this.
The leave scene of crash is 2022 CT 003146 AO.
Oh, okay. I was looking at the wrong number. All right. So the number is the 2022 CT 3146 A Orlando, Alpha Orlando. And so the 146 is what I was just speaking of. Then on that is 2021, is that right? 2021?
Mm-hmm.
Okay. CF 016071 Alpha Orlando. It is $1,500, and it's a battery on a person 65 years or older, and we'll revoke that and change it to be $3,000. Then those are the cases that she has outstanding, and now the new case is a battery case, and so this person has zero felonies and 1 misdemeanor, and so we'll go ahead and change this battery from 500 to 1,500, and the conditions of all of these are no contact with the victim or witnesses, no return to the scene of any of these cases, and no drugs, and no firearms, ammunition, or weapons. Anything else from the state?
No, Your Honor.
next we have, I guess it's Nicole Ogorick.
Yes,
Did I say it somewhat close?
yes, yes, you did, Your Honor.
All right. Ms. Ogorick, you're arrested for a misdemeanor, a battery, and I noticed that you do not have any criminal history, and so as far as I know, you're a good citizen who's got a current problem, right?
Correct.
Okay.
Your Honor.
We'll leave the, does she qualify for pretrial relief? She does not? Okay. And so you have a $500 bond, the bail. Bond is the policy, is what is put by the bond company. So that's why we really shouldn't use the word bond. Bail is what we do. So the bail is $500, and you may bond out or cash out, but bond, the bail is $500. So no contact with the victim, any witnesses, your attorney will do that. No return to the scene of this incident, and no drugs, and no firearms, ammunition, or weapons. Do you understand that?
Yes, Your Honor. I do have a question. What happens if I can't bond out or pay out? There's like, I know nobody. I'm the only one here.
Okay, you're going to have to discuss that with your attorney, really. Okay, thank you very much.
Okay, thank you.
Okay, next is Samaria Thomas.
Hey, how you doing?
And so, Ms. Thomas, you have a failure. You're already arrested previously for petty theft, and then you failed to appear in court, is the allegation, and that standard bond is $2,000. When I look at your history, I do see 10 felonies, 3 misdemeanors, and 1 prior failure to appear in court, and this is a second failure to appear in court. And so we'll change the 2,000 to be 4,000.
Your Honor, since it's another judge's capias, it cannot be changed. They would ask that it remain at 2,000.
Oh, it is? Okay, let me look. Yes, you're correct.
Sir, am I able to say something?
And so at this point, you really shouldn't. I'm just telling you why you're arrested. So since a prior judge said 2,000, then I'm supposed to respect that. And so I leave it at 2,000. All right, Ms. Thomas, thank you very much.
You done?
Okay, next is Sanders, Isaac Sanders.
Yes, sir.
Okay, Mr. Sanders.
Yes, sir.
All right, it says here that you're in jail for a misdemeanor, failure of defendant to appear in court, and you were out on bond for driving while license suspended or revoked, and then you missed a court date and therefore have a warrant for your arrest. That judge did do a $1,000 bond, or bail actually, and so we'll leave it as is. And so,
Your Honor, may we confirm something with the clerk? Mr. Sanders, I spoke before court and he informed me that this matter had been resolved. I believe he may have, did you enter a plea?
Actually, I went to court twice after this, and they offered me, on the 7th, I just took 90 days probation. 90 days probation, and I went to do my intake, and they said that I have this, and I just went to court previous 2 times for this. They resolved this matter.
okay, the state will look at it from on their computer, and what he says make any sense as far as the documents go?
I still have it open in my system.
I think he's talking about another traffic case that he had just resolved. He was placed on probation on September 7th.
Yeah, I went to both proceedings.
That's a different case.
This case, there was a plea hearing back in April, and that's what he failed to appear at. So this case has been inactive since April.
I couldn't understand you.
This case that he's here for today has been inactive since April of 2022. There was a plea hearing in April that he failed to appear at, hence the habeas.
I've been to court twice since then.
Well, I do see that you have 7 felonies, no misdemeanors, no failures to appear.
7 felonies. Not me.
But, so you would not qualify. Well,
Nothing further, Your Honor. Thank you.
all right, thank you very much. Okay, next should be David Andrews. Okay, Mr. Andrews, you're arrested for a felony. It's possession of alprazolam, and then secondly, possession of prescription drug without a prescription. And then number 3, resisting an officer without violence. And when I see you have 5 felonies, 4 misdemeanors, no failures to appear, and you've been arrested for various drug issues in the past. So, so we'll go ahead and count 1, which is possession of alprazolam, will change to $2,000, and then possession of a prescription drug without a prescription will change to $200, and then resisting an officer without violence will change to $200. And sir, you are not to return to the scene of any of these incidents. You're not to contact any victim, witness. Your attorneys will do that. You are not to, I tell you, let's go ahead and drug test him 30 days after release from jail. Let's drug test him. And then each month, random drug testing. And I do that because you've got to decide whether drugs are what you really want to do in your life, or you want to be drug-free and jail-free and trouble-free. It's your decision. All we can do is provide you with opportunity, but you've got to take it. So I'm going to drug test you every month randomly. We're going to call you to come in and be drug tested. And you just need to decide if you wish to be drug-free and to get this behind you, or you're just going to have a life of being in and out of jail and in and out of prison, eventually prison. Have you been to prison yet? You have? He says he has been to prison?
He has been.
When did you get out of prison?
May.
It was May of 21.
May of 21. You know, we call it the Department of Corrections because it's supposed to help correct people. And I was a drug court judge for 3 years, and I'm very schooled on drugs and drug addiction. And so unless you want to do another term in prison, you really need to change your life. But that's for another day and another time as far as the sentence goes. But, so, anyway, do not return to the scene of this incident. Do not contact any co-defendants or victims or witnesses. Do not consume any illegal drugs, or if you bond out, your bond will just be lost. And then do not consume any, do not possess any firearm, ammunition, or other type weapon. Do you understand that? Out of curiosity, did you do any drug programs in prison?
I wasn't there very long,
You went, how long were you there?
3 or 4 months.
Was that all? That's too bad. I say it's too bad because they do have drug programs in prison that people should take advantage of. Anyway, thank you very much. Okay, are you Mr. Blotcher?
Yeah.
And how do you say your last name?
Blocker.
Blotcher, I did.
Blocker.
Oh, like a K?
Yeah.
Blocker.
It's silent.
Okay, I see what you mean. Okay, you're arrested for a felony, driving while license revoked, habitual, meaning this isn't the first time, and also grand theft, third degree of a motor vehicle. And so, looking at, you have 4 felonies, 8 misdemeanors, 4 failures to appear in court. And so we'll change your bail to be $5,000, Mr. Clerk, and then the grand theft of a motor vehicle, $2,500. And that's the only thing I see. So you are not to return to the scene of this incident. Do not contact any co-defendants or witnesses. Your attorney will do that. Do not possess any illegal drugs. Do not possess any firearms, ammunition, or weapons of any sort, knives, that sort of thing. Okay, thank you very much. State, did I cover everything?
Yes, Judge.
Okay, next we have James Bittner.
Yes, sir. Yes, sir.
Okay, sir, you were arrested for a felony, burglary of a conveyance, petty theft, and you have 12 felonies.
Your Honor.
Oh, yes.
May defense be heard as to probable cause?
Oh, yes, sir. Go ahead.
Reading the affidavit under the totality of the circumstances, I don't know if there's enough PC for both charges, there's much less PC for the petty theft charge. One witness did say he was in the car and that quarters went missing. The other witness that held him down never saw him in the car, and I don't believe the affidavit indicates that the officer recovered any quarters on the defendant. So I'd have you consider that before determining probable cause in this case.
Your Honor, the victim of the car saw the defendant in the vehicle. Her and I believe her boyfriend then detained the defendant, and she noted that items were missing from inside the vehicle. Probable cause is an incredibly low standard. All state has to show at this point is that an item was taken. The victim says an item was taken, and it was the intent to deprive the victim of said item. It's not within the jury instruction or the statute that that item must be found on the defendant. That could potentially be a motion at a later time or a defense. That would not necessarily go towards PC. So state argues that there's enough PC for both charges, even though petty theft is arguably a lesser included of a burglary conveyance. In a way, judge can still find PC for both charges.
All right. We'll deny the motion. And, sir, your burglary of a conveyance, we'll change that to be $10,000 from the 3,500 to be 10,000. And then the petty theft, we'll leave at 250. Sir, you are not to contact the victim, any witnesses. Your attorney will do that. Do not return to the scene of this incident, and do not consume any illegal drugs, and do not possess any firearms, ammunition, or any kind of weapon. Thank you very much.
Thank you, Your Honor.
Yes, sir.
Thank you. Have a nice day.
Yes, sir. Okay, let's see. I guess this, the first name is Torres and then Callaway?
Sir.
Okay. Sir, you're out on bond of $50,150. Possession of, I can't read the, whatever that is, demi, whatever it is, with intent to sell or deliver, and then count 2, possession of meth. Okay.
State only filed on one charge, and that was the possession of the dimethylpentylone with intent to sell or deliver, which was an F2.
Okay, so you're saying count 2 never got filed on?
Yes, Your Honor.
All right, so we'll just do count 1. And so the, that large amount, did that go to the first one? I would assume.
So originally it came in as trafficking and MDA over 14 grams, which was an F1, which was that $50,000 bond. And then possession of MDMA ecstasy with intent, which was an F2, which was $10,000. But we didn't file either of those charges. When FDLE came back, it actually came back as the dimethylpentylone, not the MDA or the MDMA. Over the possession with
what do you recommend for a bond for that?
So the possession with intent to sell or deliver is an F2. He previously was arrested on an F2, the MDMA with intent to sell or deliver, and that bond was 10 grand. So I think this one is more tantamount to that 10 grand instead of that 50 grand. And Your Honor is most likely going to revoke and double, so state would ask for 20.
Okay. All right, we'll do the 20 grand for that one count. Mr. Clerk, do you have that? Okay. And then he's arrested again. That we've just been talking about history. Now we're talking about what's current. The sale and delivery of cocaine within 100 feet of a school, and sale and delivery of cocaine just generally. That's what the new charges are. And we'll go ahead and the sale of cocaine within 1,000 feet. I think I said 100, but it's really 1,000 feet of school. We'll change that from 10 to 20 because of his history. And then sale and delivery of cocaine, we'll just make that 15,000, I meant to say. And so, sir, you are not to possess any illegal drugs, and no contact with any witnesses, victims, do not return to the scene of any of these incidents, and do not possess a firearm, ammunition, or a weapon. State, did I cover everything?
Yes, Judge.
All right, thank you.
Just a moment to speak to this next client, Your Honor.
Okay, you are Ms. Campbell? All right, Ms. Campbell, you are arrested for a felony, criminal mischief, causing damage of more than $1,000, battery, resisting an officer without violence, petty theft, resisting a merchant, and looking at your history, you have 2 prior felonies, no misdemeanors, no failures to appear. State, look, having read this, I think maybe those bail amounts are correct, are adequate, I meant.
That's fine, Your Honor. She has little criminal history, so
Okay.
it wouldn't ask for it to be raised.
All right, so count one is 1,000, so basically, I'm not changing it, it'll be the same. So it's 1,000, count two is 500, count three is 500, count four is 250, count five is 500. All right, okay, all right, anything else, State?
State would ask for a no return, no contact.
Yes, thank you. No contact, no return, and no possession of firearm, ammunition, or weapons. Thank you. Next, we have Klein, Jessica Klein.
Hello.
Ms. Klein,
Yes,
you're
sir.
arrested for a felony as failure of defendant to appear.
I was in the hospital.
And this is possession of cocaine. So you have a charge, possession of cocaine, and then the failure to appear.
Yes, sir. I was in the hospital, emergency surgery. They wanted me to
So you do have a
endocarditis.
bail of $1,000.
I can't pay, is it, I can't pay that. Can you ask for PTR, please?
She's requesting pretrial release, Your
Please,
Honor.
I can't pay it, please. And I want to go home, please.
Well, let me look at, let me.
I've only, this
out
is
of
my only charge,
curiosity.
and I'd really, I was in the hospital. I'm not going to be in the hospital again. Please, sir.
Your Honor, it's a
This is my
KPS.
first FTA.
It's a KPS. Another judge signed it. This
Please.
court doesn't have jurisdiction to change it.
Say again, I couldn't.
It's a KPS, Your Honor. Another judge signed it. This court doesn't have jurisdiction to change it.
Oh, please.
A pretrial release is, does she, I don't
How
have
come
any
he can't?
history
That's
for
not
her.
fair.
We don't screen nor qualify felony FTAs, Your Honor. They don't qualify.
Oh, okay.
What does they say?
All right. The, you know, the trouble is, you may be telling me the truth, you may not be. I don't know. This isn't an evidentiary hearing in that sense. And so I would think that,
I don't have $100. Nobody's going to pay it for me.
so, so the failure to, it's $1,000 bail, and thank you very much. That's it.
I've already spent 22 days.
Next we have James Douglas. Mr. Douglas. Mr. Douglas, you're charged with a felony, burglary of an occupied structure, and then false imprisonment. And you have 3 prior felonies, 5 misdemeanors, 1 failure to appear. So we'll go ahead and change your bail from 10 to 15, and false imprisonment will change to 10. And then, sir, you are not to contact any of these people, any victim, any witness. Your attorney will do that. Do not return to the scene of this incident. Do not possess any illegal drugs, and do not possess any firearm, ammunition, or weapon. State, did I cover everything?
Yes, Judge.
Okay. All right, Francis. Here, that goes with that. Okay, Francis, Mr. Francis, you're charged with a felony, opium or delivery, trafficking, 4 grams. And then number 2 is opium or delivery, trafficking, 4 grams. So it's 2 times. And then the third one is public order crime. So, and then let's see who you are. You have 8 felonies, 5 misdemeanors. You do have a failure to appear, And so I noticed that count one is 100,000. We'll leave that as is.
Your Honor, both count 1 and 2, they're both trafficking in fentanyl, 4 grams or more. They're both F1s.
Okay, and so we'll leave the bond as is, which is 100,000 for count one, 100,000 for count two, and the public order is 500. And that seems adequate for the charges. Okay, and so thank you very much, sir. Oh, and do not return to the scene of this incident. Do not contact any of these, any victim or witnesses. Your attorney will do that. Do not possess any firearm, ammunition, or weapon. Thank you.
Yes, sir. If I might just have a moment, Your Honor. Okay. Thank you, Your Honor.
Okay, I did look at this, and the gun that's mentioned, aggravated assault with a deadly weapon, that is an air gun, which was discovered after the fact. Somebody could have shot you real easy. To have a gun that looks like a gun, to have an air gun that looks like a gun is a way to get shot by either law enforcement or by somebody else. But I am taking into consideration that it was an air gun and not a real gun. So I was actually surprised to see that you have no history. And when I read the facts, I would have assumed you had history. But the bail amount is $3,500, and since you don't have history and it didn't turn out to be a real gun, we'll leave it as is. So no contact with the victim or any witnesses, no return to the scene of the crime, no drugs, and no illegal drugs, and no firearms, ammunition, or any real weapon. And that includes a knife. So you're going to have to explain all of this at another time. All right, thank you very much. State, did I cover everything?
Yes, Judge.
Call.
Okay, next we should have, let's see, Garibaldi-Baez, Francisco. Okay, sir, you're charged, well, you're out on bond in a prior case, and that's the case that ends in 9267. It was a $5,000 bond, so we'll revoke that and make it $10,000. And like I said, that is the one that is 9267. And then there's a second. He was out on bond on a second case where it is 8905 is the part of the case number, and it was 2,000. So we'll change that to be 5,000. And that's a grand theft of a motor vehicle. And now that's just history, and it's like current history. They're still pending. Now we have possession of cannabis and possession of drug paraphernalia. you have 6 felonies, 1 misdemeanor, no failures to appear, and so, so we'll go ahead and change the possession of the cannabis to $2,500 and possession of paraphernalia to $1,000. And that you are not to return to the scene of this crime, not to contact any victim or witnesses, not to possess any illegal drugs, and no firearms, do not possess a firearm, ammunition, or any kind of weapon. All right, state anything else?
No, Your Honor.
Your Honor, Robert Gunn refused.
Okay.
We'll waive the appearance, Your Honor.
Okay. The possession, he's arrested for a felony, possession of meth, possession of drug paraphernalia. He has 4 prior felonies, 4 misdemeanors, no failures to appear. And so we'll change the count 1 to 1,000 and then count 2 to 500. And he is to not contact any victim or witnesses, no return, no firearm, ammunition, or weapon. State anything else?
No, Judge.
Next, we should have Hardy, Darius Hardy.
Yes.
Okay, Mr. Hardy, you're arrested for a misdemeanor, a petty theft. The bail is set at $1,500. And any resolution for this?
No, Your Honor, not at this time.
Okay, all right, your bail is $1,500. So if you, when you post bail, do not go back to the scene of this incident. Do not contact any witnesses or victims. Do not possess any drugs, and do not possess any firearms, ammunition, or weapons. State anything?
No, Judge.
Did you address both of them?
There's another.
He has 2 cases.
Oh, there is 2 cases?
Yes.
We need him back.
All right, let me, yeah. Okay, yes. Yes, here it is. Okay, I didn't realize you had a second case, which is you're arrested for possession of cocaine, and that's $1,000 bail. Those same conditions, Mr. Clerk, is to be in this one too. So you have $1,000, and then you have the prior one. Okay, thank you. Okay, and next we have Jermaine Hester. Mr. Hester, this is a felony, possession of a controlled substance 1 time, 2 times, 3 times, and then a drug paraphernalia. Those are the charges that have been filed. And looking at your history, you have 6 felonies in the past, 5 misdemeanors, 4 failures to appear. And so the possession of controlled substance, Mr. Clerk, let's go ahead and change that to be 5,000, each of those to be 5,000, the first 3, and then the 4th one would change to 1,000. All right, and no contact, no return, and no firearms, ammunition, or weapons. State, anything else?
No, Judge.
Okay, Adrian Mathis, Mr. Mathis, you're out on bond already on a prior case. That case involved robbery by sudden snatching, burglary of an occupied conveyance, which is a vehicle, criminal mischief, and battery, domestic violence. So that's what you're out on. As you posted a bail of $9,000 already. So we'll go ahead and double everything. So it'd be 18,000. And so the easy way to do that is just whatever each one of those are, you just double it. And so that would be what it would be. And so then the new...
Count doubled, Your Honor, at whatever that is.
I'm sorry.
Do you know
I don't. I have a total amount of 9. So what is, okay, let's,
I'm trying to look it up,
yeah.
Your Honor.
Yeah,
Count 1 was 5,000, so that would be 10,000. Count 2 was 2,500, so that would be 5,000. Count 3 was 1,000, so 2,000. And then count 4 was 500, so doubled would be 1,000.
okay. Pretrial release, thank you very much. Okay, now the new charges. Possession of burglary tools and loitering and prowling. And so, based on the prior situation, we'll change the bail to be $1,000 on count 1, possession of burglary tools, and then loitering and prowling, we'll do it 500. And no contact with the victim or witnesses, no return to the scene of this incident, no weapons or ammunition or firearms. All right, state anything?
No, Judge.
Okay, next would be, the last name is Neves-Camacho. Okay, all right, Mr. Neves Camacho. Let's see. I guess, okay, this is a correction by the jail. And so pretrial release, Martha, do you do this, pretrial release? Do you,
No, we don't do
correction?
that. We don't do
Okay,
the-
so I guess it says, all right, I have a possession of, I guess the bond amount is to be corrected, to be determined. It says bond amount to be determined. See, possession of a firearm by a convicted delinquent, and then possession of ammo by a convicted delinquent. And then, so I guess, let me see what case, booking. Okay, that's the case that ends in 775. Okay, it must be, okay, we're going to first talk about a case that is 2022 CF 10775. And so possession of a firearm by a convicted felon, that would be $20,000. And possession of ammo by a convicted delinquent, that'll be $10,000. And then we have another separate case which is 2022 CF 315. And it doesn't show on my piece of paper, it just says amount.
Your Honor, there's 2 more charges on that case, on the 10775.
Oh, let me go back. 775?
Yes.
I just showed 2.
There's,
Oh, it's referring here? Okay, now I understand what that sheet was doing. So I guess we'll put them together and then we'll deal with that. So the 775, okay, 775, apparently there's 4, 5, 6? No.
4 counts.
4, and so, let me see. Okay, I see what it's doing now. Okay, so this is really, so count 1 is possession of a firearm by a convicted delinquent. I've already said that. You have that? Okay, and then count 2, possession of the ammo, which I already gave you, and then possession of cannabis. So we'll do that at $1,000, and then possession of drug paraphernalia, we'll do that at $500. And I think we've got 775 now. Okay. Now, in addition to that, you're out on bond for carrying a concealed firearm, and we'll go ahead and that is the case that ends in 2022 CF 315. So we're all together on that. And so it doesn't show here what it was.
It was $2,500.
It was $2,500, so we'll change that to be $20,000. Okay, all right, I think we're done with that. And then no contact, no return, no firearms, ammunition, weapons. State, anything else?
No, Judge.
Thank you. Okay, Christy Patrick? Okay, Mr. Patrick, you're out on bond. And so looking at your surety bond that you're out on bond on, fleeing and attempting to elude law enforcement, sirens and lights, runaway? No, what is it? I can't read the
Your
abbreviation.
Honor, it originally came in with 5 charges. We ended up only filing 1. We only filed the fleeing and attempting to elude with lights and sirens activated.
Okay, all right.
I believe that originally came in.
Okay, now, thank you for that information. That's good information. 4 felonies, 7 misdemeanors, 2 failures to appear. So we'll just, we'll treat it as 1 count, which is fleeing and attempting to elude, and we'll go ahead and make that $20,000. And then looking at the new ones, new charge, possession of cannabis with intent to sell, distribute, possession of cannabis, and then secondly, and then possession of drug paraphernalia. We'll go ahead and possession of cannabis with intent to sell. We'll go ahead and make that $2,500. And then possession of cannabis, we'll do it at $1,000, and paraphernalia at $500. And sir, you are to not contact any witnesses or victims. Your attorney will do that for you. Do not return to the scene of this incident. Do not consume any illegal drugs. Do not possess any firearms, ammunition, or weapon. State, did I miss anything?
No, Judge.
Okay, let's see, Danielson, okay, all right, we'll set it over to tomorrow.
We'll waive the appearance, Your Honor, for today.
Okay, all right, this is the box cutter situation. Let's see, burglary of a conveyance, aggravated assault with a deadly weapon, and the deadly weapon is a box cutter. And correct me if I'm not remembering it correctly.
That's correct, Your Honor.
Aggravated assault with a deadly weapon, which is the box cutter. This person has no felonies, only 2 misdemeanors, 1 failure to appear, however. The aggravated assault on burglary of a conveyance will leave as the 5,000 is fine. Aggravated assault with a deadly weapon, we'll do that at 10,000, and aggravated assault with a deadly weapon, secondly, we'll do that at 5,000. And then he's to have no contact with the victim or witnesses, no return to the scene, no drugs, and do not possess any firearms, ammunition, or weapon. State, anything else?
No, Judge.
Okay, this is Sneed. Okay, Sneed is a refusal.
We'll waive that appearance as well, Your Honor.
Okay, all right, we're looking at the ROR, and we'll revoke that, and then we'll make a bond. I'm looking at he's when you look at his history, he has a fair amount of history that goes over to the second page. But I'm confused. Okay, felony 0, misdemeanor 4, failure to appear 2, and then I guess the rest of these were just simply arrests that were not filed on. And so the burglary of a structure or conveyance, that's count 1, I presume. And so we'll go ahead and do that at 10,000. Grand theft, 3rd degree, 5,000. Criminal mischief, 1,000. And then that's what he's out on now.
20,000 or 10,000 for count 1, Your Honor?
10.
Was it 10?
Yeah, 10, 5, and 1.
Yeah, 10, 5, and 1. Then next, he's arrested for lewd and lascivious battery and contributing to delinquency of a minor. And state your suggestion on count 1.
Your Honor, count 1, due to the way it's charged, is an F2. So he is entitled to bond. It is not a PPL. So state would ask that you set a reasonable bond.
All right.
I believe the alleged age of the child was 14.
Okay. All right, we'll do 20,000, and then contributing to delinquency of a minor, 10,000. And no contact with children, no contact with the victim, witnesses, and no return to the scene, and no drugs, no firearms, ammunition, or weapons. State, did I forget anything?
No, Your Honor.
Next, we have extortion. This is Mr. Thurman?
Yes, sir.
Mr. Thurman? Okay. You're arrested for a felony. It says extortion. I don't see any prior felonies or misdemeanors or failures to appear. This is a He was picked up on a warrant. The prior judge did a $5,000 bail, and so we'll leave that as is. And so unless the state tells me otherwise, we'll leave it at 5,000. So do not return to the scene. Do not contact the victim or witnesses. Do not possess any illegal drugs. Do not possess any firearm, ammunition, or weapons. State, did I get everything?
Your Honor, state would ask for no use of the app Tinder,
I'm sorry, no use of what?
of the dating app Tinder.
Oh, dating apps, Tinder.
Yes.
Okay, Tinder, I guess the dating app Tinder, so, okay. But, you know, there's probably a dozen of those things. If you just say no Tinder, the person would just use something else. And so, all right, anything else?
No, Judge.
Okay.
The other warrant, or the warrant specifies not using Snapchat Messenger, I think.
Okay, Snapchat, and is that different? So there's Snapchat and then there's Messenger? Oh, that's one. Okay, yeah, write it to where someone who knows what that is can understand it. Okay, thank you. Next is Joseph Torres. All right, Mr. Torres, you're out on bond already on a case, driving while license suspended as a habitual offender, $2,500. So we'll revoke that and change that to be 5,000, Mr. Clerk. And and then you are now arrested for a new charge, which is grand theft motor vehicle. And looking at, you have 8 felonies, 10 misdemeanors, 1 failure to appear. So we'll go ahead and change the grand theft of motor vehicle to be $15,000. And so no contact, no return to the incident, scene of the incident, no drugs, no weapons, firearms, ammunition, or weapons. State, anything else?
There's 2 additional cases, Your Honor.
Oh, there is? Okay, let me.
It also has a resisting and another dwellis.
Oh, okay. Okay, here's here's the case that ends in 6313, resisting an officer without violence. We'll change that to be $2,000 with the same conditions. And then we have driving while license revoked as habitual offender. And we'll change the 2,500 to 5,000 because of his history. Okay, State, anything else?
No, Judge.
Next, we have Torres. Mr. Torres?
We just saw Torres, Your Honor.
Oh, I'm sorry.
Next is Wilburn.
Yeah, sorry. Okay, there's Torres, okay. Wilburn, Edward Wilburn. Okay, sir, you're arrested for a felony, grand theft, 3rd degree of a motor vehicle. You have 23, you don't look that old, 23 felonies, 29 misdemeanors, 6 failures to appear. And so we'll go ahead and change his bail. Since he has 6 failures to appear, we'll change his bail to $30,000. $30,000.
Your Honor, the last failure to appear was in 2004.
Say again?
The last failure to appear was in 2004, just for the court's consideration.
State, do you want me to consider that?
Yes, Your Honor. I mean, it's part of his criminal history, but the state will leave it within your discretion.
Would the court consider a $10,000 bond instead?
Well, there's 23 felonies, 29 misdemeanors. It's like almost 50 criminal actions. And with 6 failures to appear, I really, I'm not sympathetic. I think that's a really high risk of not appearing. And so we'll leave it at 30,000. So no contact, no return, no weapons, ammunition, or firearms. Okay, what do we have left? Okay.
I believe there's the 133-day motion that we skipped.
Yes. This is Cesare, I can't even read the name.
Cesario Cacall, 22 CF 9545.
Yes.
Granted, notice of non-filing.
Okay, anything more from the clerks? We're good. The clerks say we're good. Attorneys, are we good?
Yes, Judge.
Thank you very much.